I'm typing up rebuttals right now. That's right.
Good morning. The Judiciary Committee will come to order, and without objection, the chair is authorized to declare a recess at any time. Pursuant to notice, I now call up H.R. 1667 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 1667, to amend Title 11 of the United States Code in order to facilitate the resolution of an insolvent financial institution in bankruptcy.
Without objection, the bill is considered as read and open for amendment at any time, and I'll begin by recognizing myself for an opening statement. In 2008, our economy suffered one of the most significant financial crises in history. In the midst of the crisis, and in response to a fear that some financial firms' failures could cause severe harm to the overall economy, the federal government provided extraordinary taxpayer-funded assistance in order to prevent certain financial firms' failures. In the ensuing years, experts from the financial, regulatory, legal, and academic communities have examined how best to prevent another similar crisis from occurring and to eliminate the possibility of using taxpayer monies to bail out failing firms. The Judiciary Committee has advanced the review of this issue with the aim of crafting a solution that will better equip our bankruptcy laws to resolve failing firms while also encouraging greater private counterparty diligence in order to reduce the likelihood of another financial crisis. Among other things, this effort responded to provisions of the Dodd-Frank Wall Street Reform and Consumer Protection Act that called for an examination of how to improve the bankruptcy code in this area. During the past two Congresses, the Judiciary Committee favorably reported the Financial Institution Bankruptcy Act, legislation that improved the bankruptcy code to better facilitate the resolution of financial firms. That legislation was the culmination of a bipartisan process that solicited and incorporated the views of a wide range of leading experts and relevant regulators. In both instances, the bill passed the House by voice vote under suspension of the rules. This Congress, Regulatory Reform, Commercial and Antitrust Law Subcommittee Marino reintroduced the Financial Institution Bankruptcy Act as H.R. 1667. Following its introduction, the Subcommittee on Regulatory Reform, Commercial and Antitrust Law conducted a hearing on the bill. H.R. 1667 is identical to previous legislation with one minor change to refine the director liability protection provision. The bill before us today is the product of a careful, deliberate, and thorough process and reflects a diverse range of views from a variety of interested parties. The Financial Institution Bankruptcy Act makes several improvements to the bankruptcy code in order to enhance the prospect of an efficient resolution of a financial firm through the bankruptcy process. The bill allows for a speedy transfer of the operating assets of a financial firm over the course of a weekend. This quick transfer allows the financial firm to continue to operate in the normal course, which preserves the value of the enterprise for the creditors of the bankruptcy without a significant impact on the firm's employees, suppliers, and customers. The bill also requires expedited judicial review by a bankruptcy judge randomly chosen from a pool of judges designated as advanced and selected by the Chief Justice for their experience, expertise, and willingness to preside over these complex cases. Furthermore, the legislation provides for key regulatory input throughout the process. The Financial Institution Bankruptcy Act is a bipartisan, balanced approach that increases transparency and predictability in the resolution of a financial firm. Furthermore, it ensures that shareholders and creditors, not taxpayers, bear the losses related to the failure of a financial company. I would like to thank Chairman Marino for introducing this legislation. I am also pleased that Ranking Member Conyers and Subcommittee Ranking Member Cicilline joined in introducing this important legislation and want to thank them and their staff for their efforts in developing this bill. I urge my colleagues to support this important legislation, and it's now my pleasure to recognize the gentleman from Rhode Island, the ranking member of the Subcommittee on Regulatory Reform, Commercial and Antitrust Law, Mr. Cicilline, for his statement.
Thank you, Mr. Chairman. In 2008, the United States economy nearly collapsed as a direct result of lending practices in the housing market that were predatory, unsafe, and in many cases fraudulent. Investments in toxic securities created a cycle of failure in the housing market. The declining health of the market undermined the value of these securities, which in turn devastated the housing market and caused the failure of several of the nation's largest financial institutions. With the financial system in near collapse, large financial institutions were essentially able to blackmail the government because these banks were so large that there was no way to break them apart, as then FDIC Chair Sheila Bair testified in 2009. Although the true hardship caused by this widespread fraud is incalculable, we do know that it erased $10 trillion of household wealth and caused 8 million Americans to lose their jobs and 5 million Americans to lose their homes. Rhode Island, my home state, was hit particularly hard by the recession. When I took office, the unemployment rate in Rhode Island hovered at 11.2%, the fifth highest in the country. In the wake of this economic disaster, the Dodd-Frank Act was enacted to comprehensively reform the financial system. Because of this law, which includes some of the strongest consumer protections passed since the Great Depression, the banking system is stronger, there's more transparency in consumer lending, and the Consumer Financial Protection Bureau continues to serve as an important watchdog to protect Americans against predatory lending and fraud in the financial system. Title I of Dodd-Frank provides stability in markets by requiring large financial institutions to have a living will to serve as a plan for the rapid and orderly resolution in the event of material financial distress or failure. Title II ends taxpayer bailouts of banks that are too big to fail by providing financial regulators with orderly liquidation authority where a bank's collapse would have serious adverse effects on financial stability in the United States and no viable private sector alternative is available. This process expressly requires a finding by the Secretary of the Treasury that the bankruptcy process would not be appropriate to resolve a distressed firm. Leading commentators agree, however, that the U.S. bankruptcy process is not designed to accommodate the orderly resolution of a large financial institution that poses systemic risk to the entire economy. H.R. 1667, the Financial Institution Bankruptcy Act, addresses this concern by establishing a single point of entry for the resolution of an insolvent financial institution with assets exceeding $50 billion. The goal of the bill is to establish a process where a distressed financial institution could voluntarily seek bankruptcy relief while its subsidiaries continue to operate. And while I strongly support H.R. 1667 and am original co-sponsor of the bill, make no mistake, I will strongly oppose any effort to combine this measure with the repeal of the Dodd-Frank Act or any part of the law for that matter. Since this law was enacted, the economic recovery has led to the creation of more than 15 million private sector jobs, a 60% increase in business lending, and record performance by the Dow Jones Industrial Average. It's critical that we build on this progress through education, training, and other initiatives to promote economic opportunity. Too many Americans are still unemployed or working 2 or even 3 jobs just to get by, while Wall Street has never been better. We must also preserve and advance the protections established by Dodd-Frank to ensure transparency and stability in the financial system while protecting consumers. The National Bankruptcy Conference agrees with this assessment and has previously instructed that the Dodd-Frank Act should, quote, continue to be available even if the bankruptcy code is amended to better address the resolution of SIFIs, because the ability of U.S. regulators to assume full control of the resolution process to elicit the cooperation from non-U.S. regulators is an essential insurance policy against systemic risk and potential conflict and dysfunction among the multinational components of SIFIs, end quote. Moreover, should this legislation become law, Dodd-Frank provides a valuable backstop to bankruptcy through its orderly liquidation authority, which empowers the Federal Deposit Insurance Corporation to act as a receiver for large financial institutions that are too big to fail. I urge my colleagues to support this legislation and yield back the balance of my time.
It's now my pleasure to recognize the ranking member of the Judiciary Committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte. I think that because of the urgency of us moving as rapidly as we can, and because I sense a strong sense of cooperation on both sides of the aisle on this matter, I'm going to put most of my statement in, but as an original co-sponsor of this measure, I agreed to co-sponsor for several reasons. To begin with, 1667 addresses a real need recognized by regulatory agencies, bankruptcy experts, and the private sector, that the bankruptcy law must be amended so that it can expeditiously restore trust in the financial marketplace after the collapse of a systematically significant financial institution. As many recall, the failure of Lehman Brothers and subsequent bankruptcy in 2008 caused a worldwide freeze on the availability of credit. This in turn triggered the near collapse of our nation's economy and clearly revealed that current bankruptcy law is ill-equipped to deal with complex financial institutions in economic distress. H.R. 1667 would establish a specialized form of bankruptcy relief designed to facilitate the expeditious resolution of a large, systemically significant financial institution. Under the bill, the debtors' operating subsidiaries would continue to function outside of bankruptcy, while the debtor's principal assets, such as its secured property, financial contracts, and the stock of its subsidiaries, would be transferred to a temporary bridge company. The so-called bridge company, under the guidance of a trustee, would then liquidate these assets to pay the claims of the debtor's creditors. The bill would also temporarily prevent parties from exercising their rights in certain qualified financial contracts. Each critical step of this process would be done under the supervision of a bankruptcy judge and subject to appeal. And finally, I support this bill because it is a bill that appropriately recognizes the important role the Dodd-Frank Act has in the regulation of large financial institutions. Without doubt, the Great Recession was a direct result of the regulatory equivalent of the Wild West. The Dodd-Frank Act goes a long way toward reinvigorating a regulatory system that makes the financial marketplace more accountable and hopefully more resilient. In particular, Title II of Dodd-Frank establishes a mandatory resolution process to wind down large financial institutions, which is a critical enforcement tool for bank regulators to ensure compliance with the Act's heightened regulatory requirements. 1667 is an excellent complement to Dodd-Frank Act's resolution process and will help facilitate the rapid administration of a debtor's assets in an orderly fashion that maximizes value and minimizes disruption to the financial marketplace. And so I urge my colleagues to continue the bipartisan support for this measure, and I thank the chairman for the time.
Chair thanks the gentleman. Are there any amendments to H.R. 1667? A reporting quorum being present, the question is on the motion to report the bill H.R. 1667 favorably to the House. Those in favor will say aye.
Aye.
Those opposed, no. The ayes have it, and the bill as amended, the bill is ordered reported favorably. Members will have 2 days to submit views.
Good. Unanimous.
Pursuant to notice, I now call up H.R. 1695 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 1695, to amend Title 17 United States Code to provide additional responsibilities for the Register of Copyrights and for other purposes.
Without objection, the bill is considered as read and open for amendment at any time, and I'll begin by recognizing myself for an opening statement. Register of Copyright Selection and Accountability Act of 2017 fills a critical gap that currently exists in the selection process for all future registers of copyright. No member on this committee nor in Congress would underestimate the importance of the copyright economy in America. The copyright economy is a key driver of our nation's exports. Overseeing this sector is the Copyright Office, an entity whose large impact is far bigger than its small footprint. Over the past several years, this committee has heard from a range of perspectives about various concerns in copyright law, ranging from industry-specific concerns to much broader ones, especially the Copyright Office itself. Since November 2014, the status and selection process for the register position has been among these concerns. The current vacancy within the registrar's office is a timely one as we consider the Copyright Office of the future. But we should not hold up replacement of the register to resolve the other issues that will take more time to address. So I and 29 of my colleagues introduced this legislation as a way to speed up consideration of this key component before other changes to the Copyright Office are made. We have also worked in tandem with the Senate Judiciary Committee, whose bipartisan leaders share our concern that we need to act while the register position is vacant. With the enactment of this legislation, both the head of the Patent and Trademark Office and the Copyright Office would be subject to a nomination and consent process. The lack of a nomination and consent process for the register has led to repeated litigation that this legislation would finally resolve. The legislation also creates a matching 10-year term for the Register of Copyright and the Librarian of Congress. A 10-year term is sufficient for the next register and all that follow to make major changes on Copyright Office operations without worrying about a short time span to make these changes. Since the Copyright Office is part of the legislative branch, I understand an amendment will be offered to ensure that members of Congress pick the slate of candidates from which the President must choose a nominee. In addition to the strong support from within the committee, I'm pleased to see more than 30 groups have issued statements in support of the legislation. I want to also thank the gentleman from Michigan, the ranking member, for working closely in a bipartisan fashion with a number of members on both sides of the aisle to bring forward this legislation. Without objection, I am adding a list of supportive groups and their statements of support into the record, and it's now my pleasure to recognize the ranking member for his opening statement.
Thank you, Mr. Chairman. Members of the committee, as an original co-sponsor and strong supporter of 1695, I'm proud to advocate support for this measure. And also I want to mention a very important Jackson Lee amendment that will soon be coming forward. This bipartisan and bicameral legislation was developed in collaboration with our Senate colleagues, Senate Judiciary Committee Chairman Chuck Grassley, Dianne Feinstein, Senator Pat Leahy, the chairman of our committee, and myself. It's also the product of more than 4 years of hearings and conversations with a wide range of stakeholders who all wish to see a copyright office that is responsible to all the stakeholders in the copyright ecosystem. I support this legislation for several reasons. To begin with, elevating the stature of the register and making the position directly accountable to Congress. And that would help ensure a strong and vibrant copyright system which creates jobs and promotes a diverse range of views. Today, core copyright businesses contribute more than $1.2 trillion to our economy each year, generate foreign sales of almost $180 billion, and they're also tremendous job creators, employing more than 5.5 million workers. This is why this bill is strongly supported by several unions, including the Screen Actors Guild, the American Federation of TV and Radio Actors, as well as the Directors Guild of America. In addition, an effective copyright system enables a broad range of independent and diverse voices to emerge, secure in the knowledge that they will be rewarded for their efforts. I would also point out that this bill grows directly from the bipartisan copyright review process that Chairman Goodlatte himself initiated back in 2013. This committee held 20 hearings and heard from 100 or more witnesses about how to update the copyright laws for the 21st century. As a result of this process, a strong bipartisan consensus emerged that the Copyright Office needs to be more accountable to Congress and that it should have greater independence. The Copyright Office has a long and distinguished history of serving as an advisor to Congress on copyright matters, and it's only reasonable that Congress play a role in deciding who leads that important office. Finally, requiring the register to be confirmed by the Senate will allow Congress to ensure that the Copyright Office is led by a well-qualified individual who's responsive to Congress, the public, and all the stakeholders in the copyright community, as well as establish the Copyright Office on much firmer constitutional support. I will be supporting an amendment by the gentlelady from Texas that would strengthen the selection process by establishing an even larger role for Congress in choosing the candidates for the position than the base text does. And so accordingly, I look forward to supporting that amendment as well as the underlying bill, and I urge the support of all my colleagues on the committee. I thank the chairman. Yield back.
The chair thanks the gentleman. For what purpose does the gentlewoman from Texas seek recognition?
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment.
Amendment to H.R. 1695 offered by Ms. Jackson Lee of Texas. Page 2, line 12.
Without objection, the amendment is considered as read, and the gentlewoman is recognized for 5 minutes on her amendment.
I thank the chairman. For those of us who have been engaged in this process, we know that there is a great need for change and improving and addressing the particular entities that deal with the copyright, particularly, as Mr. Conyers has said, the Copyright Office, those who provide a trillion-plus infusion of dollars to the economic engine of this country, that the Register of Copyrights Selection Accountability Act was to respond to the needs of that community to ensure that the Register of Copyrights, who is the director of the United States Copyright Office, that's housed in the Library of Congress, be profoundly competent and proficient. H.R. 1695 takes the position of the Register of Copyrights and makes it a presidential appointment subject to Senate confirmation. I believe the Jackson Lee Amendment improves the bill. The Jackson Lee Amendment improves the bill by establishing a 7-person panel to recommend a list of at least 3 individuals to the President for appointment as a Register of Copyrights. Let me be very clear that we are delighted to have as our new librarian, Ms. Carla Hayden, who has distinguished herself professionally and is committed to distinguishing herself in the running of the Library of Congress and the recognition of the importance of the rights of those who are subject to the importance of the Register of Copyrights. This amendment provides the panel membership shall be as follows: Speaker of the House of Representatives, President Pro Tem of the Senate, Majority Leader of the House of Representatives, Majority Leader of the Senate, Minority Leader of the House of Representatives, and Minority Leader of the Senate, and the Librarian of Congress. To have that extensive and important expertise to be able to ensure that this process reflects all of the needs of the Copyright Office and all of the needs of the Librarian of Congress or the Library of Congress. This bill is a product of years of deliberation and reflects the collective and considered judgment of members of Congress that the Copyright Office would be strengthened as an institution where the register to be selected through the advice and consent process, regardless of the decision maker ultimately. The dual role of the Library of Congress as both legislative and national institution also ensures that it is important to have this appointment if this bill is to pass. As its name reveals, the library is the Library of Congress, a fact in which the Congress of the United States takes great pride and of equal importance, if not more so. It is a national library that serves all of the people of the United States. I would like to think that the Jackson-Lee Amendment seeks to balance the respect for our new Librarian of Congress and the dual interests that are so important as it relates to the institution of the Office of the Register of Copyrights, and giving that office its added measure of status and authority. So I would ask my colleagues to support the Jackson-Lee Amendment, and I yield back my time.
The chair thanks the gentlewoman and recognizes himself in support of the amendment. I want to thank the gentlewoman from Texas for offering this amendment. The Register of Copyrights advises Congress, and it is critical that members of Congress have the full confidence in whoever is chosen to be register. Congress has a role in the selection of candidates for other legislative branch agencies, such as the Comptroller General of the Government Accountability Office, the Congressional Budget Office, and the Architect of the Capitol, and the gentlewoman's amendment would continue this tradition. I welcome her effort to ensure that members of Congress have input on who the next register is, and I urge my colleagues to support her amendment. Where's the gentleman from New York? Seek recognition.
Strike the last word.
The gentleman is recognized for 5 minutes.
Mr. Chairman, since 2013, under your leadership, along with Ranking Member Conyers, this committee has undertaken a comprehensive review of the copyright law and the Copyright Office. Over the course of 20 hearings with 100 witnesses, as well as listening sessions across the country, and individual meetings with a broad range of stakeholders, we have heard one consistent message, that the Copyright Office must be modernized to meet the needs of the public and the copyright community. This legislation is an important first step in that process. Under current law, the Register of Copyrights, who leads the Copyright Office, answers solely to the Librarian of Congress. As an institutional matter, this creates a conflict. Libraries are a key stakeholder in the copyright ecosystem, but they are just one of many stakeholders, each with different priorities and interests. To place the fate of the Copyright Office in the hands of one interested party does a disservice to the copyright system it is charged with administering. This bill would remedy this problem by making the Register of Copyrights a presidential appointment subject to Senate confirmation and setting a 10-year term for the position. It would establish an open and transparent process for publicly vetting a nominee for register and provide a stronger means for Congress to provide meaningful oversight of the Copyright Office. This is especially important in light of the historic role the Copyright Office has always played in providing independent advice to Congress on copyright matters. The Copyright Office lacks autonomy over its budget, over its staffing, and over its technology needs. Consequently, it has been unable to implement the modernization plan that it needs in order to function properly in the 21st century. This bill would make the Register more responsive and accountable to Congress, but it is just the first step in a process that will provide the Copyright Office with more flexibility and independence. The Jackson-Lee Amendment, which strengthens the underlying bill by giving Congress an additional role in the selection process and by including the librarian in this process. By creating a panel of congressional leaders along with the Librarian of Congress to recommend names to the President, this amendment would minimize the risk that any president nominates someone unqualified or otherwise unacceptable to Congress. Furthermore, the librarian would collaborate with Congress in picking the slate of candidates to present to the President, thereby ensuring that she continues to play a role in filling the position of Register. As I mentioned earlier, I support this bill because there is an inherent institutional conflict in leaving the choice of Register solely within the discretion of the librarian. Dr. Hayden is an impressive and well-qualified Librarian of Congress, and this legislation should in no way be seen as an aspersion on her personally or professionally. but as a matter of policy, it makes sense for the register to have a degree of independence from the librarian and to have direct accountability to Congress. The Jackson-Lee amendment strikes a good balance between Congress, the President, and the librarian in the process for selecting the Register of Copyrights. Consequently, I support this amendment. I hope all of my colleagues will support the amendment as well as the bill. Thank you, and I yield back the balance of my time.
Chair thanks the gentleman. For what purpose the gentleman from California seek recognition?
To strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, I'm going to be supporting this amendment, and I'd ask unanimous consent that the text of an amendment I will not be offering be placed in the record at this time.
Without objection, it will be made a part of the record.
Thank you. As this legislation goes to the Senate, I trust, we will all be looking carefully at making sure that we get this right. The Copyright Office is not simply a mechanism, but it is in fact a constitutionally empowered and requirement, and one that we should take seriously. For more than a century, the Copyright Office has been within the library, not because of a specific plan by our founders, but because of the power and influence of a librarian. For that reason, I think it's very appropriate that we today recognize that there are reasons that in the future we must balance the strength or weakness of a librarian, the whims or prejudice of a librarian, the capability of a librarian, the interest of a librarian, or in fact the lack of interest of a librarian, against those of our constitutional responsibility to both protect copyrights and, quite frankly, to modernize the Copyright Office. So I want to thank the chairman for bringing this up, and I want to make sure that, if you will, we make the record complete. The record, in my opinion, is as follows. The House and the Senate were not informed before the librarian made a decision to terminate the previous director. And that, in no small way, violates the spirit of the relationship that has occurred between this committee over more than a century and the librarian. Additionally, the librarian currently believes that she can hire anyone she wants and then fire them if she chooses. I believe that the chairman's legislation, including with the amendment, will make it clear that Congress has an obligation, an interest, and a continued oversight role over the success of the Copyright Office. That is not to indicate that this committee oversees the Library of Congress in any way, in any substantial way, but rather that this particular embedded part of the library is and will continue to be the primary jurisdiction of this committee and the interest of its members. Additionally, Mr. Chairman, I look forward to us recognizing under whoever shall be picked by the President, should this law be enacted, as somebody who will take charge in a serious way with modernizing the Copyright Office. For too long, both sides have asked us when we're going to modernize the Copyright Office, when the databases in copyright will begin to equal that in PTO and go beyond it, which is necessary when we consider the vast amount of stakeholders who have copyright rights that are not being found and thus not being compensated. This affects those willing to pay in addition to those willing to receive their royalties. So, Mr. Chairman, your leadership has been critical in this way. I thank you for bringing it. I also thank the gentlelady from Texas for her amendment, which I think is clearly appropriate and necessary, and I yield back.
Chair thanks gentlemen. For what purpose does the gentlewoman from California seek recognition?
To strike the last word.
Gentlewoman is recognized for 5 minutes.
Well, I appreciate that Ms. Jackson-Lee is attempting to fix the bill that has many problems. I don't think the amendment does, in fact, fix the underlying problems in the bill. The bill really is a vote of no confidence in the Librarian of Congress. By voting yes, we're saying she's incapable of appointing the registrar. We'll take this away from her and give it to the President of the United States instead. That's a bold position to take, considering that it's my understanding a majority of the members of this committee haven't even had a chance to meet Dr. Hayden, let alone ask her about her plans to modernize both the library and the Copyright Office. She was hired for this job because of her leadership and success in modernizing the Baltimore Library. Now, she's not going to personally program the web services or build databases, but she's shown that she knows how to hire and manage people who can do that. And as an aside, when she was at the American Library, she went head-to-head with then Attorney General John Ashcroft over the Patriot Act. Her particular concern was the intrusiveness of Section 215. Ashcroft called her concerns baseless hysteria, but the whole committee knows how that turned out. Dr. Hayden and her CIO have made more progress in modernization of the Copyright Office in the last 6 months than her predecessor made in the last 10 years. They believe they can shave almost 2 years off the Copyright Office 5-year modernization plan, but that only works if there's a new registrar as soon as possible. And given the speed of Congress and the fact that the president still has 495 Senate-confirmed positions to appoint, the actual confirmation process will be extremely contentious. A vote for this bill is a vote to delay the modernization of the Copyright Office. And for what? It doesn't give any new authority or responsibility. All it will do is create more conflict during a very critical time. It's also unfair to the copyright employees who will not know who ultimately to listen to, and that is not a hypothetical. Under the previous register, the Copyright Office CIO refused to recognize the library's CIO as the superior officer. This caused all kinds of problems, including cybersecurity problems. Now, how do I know this? In addition to serving on the Judiciary Committee, I serve on the House Administration Committee, and which the House Administration Committee has jurisdiction over the library. We have had the Inspector General reports submitted to us, and there are problems with, I hate to be blunt, but there were problems with the prior librarian and the prior registrar. I will go through some of those problems when we take a look at my 3 amendments that I will offer later. I just would note, Mr. Chairman, that your reference to the CBO, the president does not appoint the CBO. And as for the administrative office of Congress, the president does appoint this position, but the House passed unanimously H.R. 2843 in 2010 to take the appointment away from the president and give it to Congress. So just a few years ago, the House thought that these legislative positions should stay in the legislative branch. I would just like to add that for many years, we had a librarian of Congress who had many strengths. I'm sure he was a historian, but technology was not one of his strengths. He neglected this function. We had a registrar who, although she complained a lot about modernization, did nothing to actually promote modernization. The Inspector General report, and I will ask to put it into the record, does point out that she started the modernization project with a modest $1.1 million in 2010. She increased that to $2 million. Ultimately, the Copyright Office spent $11.6 million on modernization and then canceled all the contracts because there was no integrity, there was no managerial experience for this. Further, on the February 2017 report discloses that the Copyright Office hid what they were doing from the library and from the Congress. They hid it, the former registrar. So now that we have, I think this bill is about accountability. We had a former regime that blew the taxpayers' money, that failed to perform. We now have a new regime that is trying to perform and is in fact performing. And instead of saying, yes, let's modernize this, let's have some accountability, We're trying to take the decision out of a new librarian who is a breath of fresh air, who actually has managerial experience, and give it to the president to pile up with the rest of the appointments he has yet to make and to delay the modernization effort. The amendment should be defeated because it doesn't solve the supervision problems, and I'll close with this. You can't have good management without the ability to remove a person who is misbehaving. In Ms. Jackson Lee's amendment, we don't solve that problem. And again, this is not a hypothetical problem. Under the bill, the appointment would be made by the president, but the management would remain in the library. Now, when the registrar refuses to come to a meeting or hides her budget from the librarian, as has happened with the prior registrar, what tool does the manager, the librarian, have to actually resolve that and to get accountability? None under the amendment. So while I respect and thank my colleague from Texas for trying to fix a bad bill, it doesn't fix it, and I think the bill itself is fatally flawed, and I yield back.
Mr. Chairman,
For the purpose of the gentleman from Michigan seek recognition.
I rise in support of the Jackson Lee amendment.
Gentleman is recognized for 5 minutes.
Thank you. I, again, want to thank the gentlelady from Texas and the offerer of this amendment. And I think it's an important amendment, and I will try to explain why. The amendment makes several changes that will help ensure greater congressional input in selecting the new registrar and guarantee that the librarian is involved with and invested in the appointment. Now, I've met Dr. Hayden several times. First, this amendment provides for input by Congress in selecting the registrar. It does it by creating a panel composed of the Speaker, the House Minority Leader, the President pro tempore, and the Minority Leader of the Senate, and the librarian, in order to develop a consensus list of recommended candidates that the President is required to select from. So we're increasing our involvement and relationship with this important office, and I think that the list that we would put together would be the one that the President would be required to select from. Everyone on the panel will be given an equal say and equal deference. Since all parties and branches will be given a role, there will be a strong incentive for everyone to work together to identify the strongest and most qualified candidates. This is similar to a formula that has worked very well in identifying individuals to serve as architect of the Capitol and the Comptroller General. Secondly, I very much appreciate that the amendment will carve out an important role in the selection for the librarian. I have a great deal of respect for Dr. Hayden, was present at her swearing-in last year, and has spoken and met with her, as I've indicated, on several occasions. She brings a wealth of knowledge and experience to the table, and we should welcome that input. Finally, on a personal level, it's my sincere hope that this amendment will allow as many of our members as possible to come together as we begin the next stage of our work, updating our copyright laws, which is so central to our nation's economic and cultural well-being. This is only the first initial legislative step, and we remain open to working with every member and every stakeholder at every step of the way, including the leadership on both sides of the aisle. And so I want to thank again the gentlelady from Texas, Ms. Jackson Lee, and urge support of this amendment as we continue to enhance and improve our committee's work in this area. I thank the chair and I yield back.
For purpose of gentleman from Florida, seek recognition.
Move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Chairman Goodlatte. I am proud to join the majority of my committee colleagues as a co-sponsor of this bill, and I strongly support Ms. Jackson Lee's amendment. The bill today reflects the general consensus that Congress needs to step in to increase the autonomy of the Copyright Office, while still respecting the historic connection of the Copyright Office to the library. The bill is an important first step in reforming the Copyright Office, but it cannot be the only step. Through the hearings this committee has held over the past few years, we've learned how truly behind the curve the Copyright Office is. I still can't believe that the Copyright Office uses a card catalog, something that many young people have never seen and would have no idea how to use. Mr. Chaffetz and I have worked to find a bipartisan and consensus-driven set of reforms for the Copyright Office that would go beyond just the selection of the register, as have the chairman and ranking member Conyers and others on the committee as well. Establishing the Register of Copyrights with authority outside the Library of Congress is not a reflection on Dr. Hayden. It's a recognition of the reality that the Library and the Copyright Office have two fundamentally different missions and deserve to be empowered to pursue those two missions. It is a recognition that success for both of those important entities means allowing them to maintain their historic connection, but to operate on a day-to-day basis with greater autonomy. This change was true when Dr. Billington was in charge of the library, and it remains equally true with Dr. Hayden in charge of the library. Dr. Hayden has many challenges in her work to bring the Library of Congress into the 21st century and to make this world-class library accessible and relevant to all Americans. And while we haven't discussed much of that, because most of her mission is outside the jurisdiction of this committee, I would use this opportunity to note that Congress needs to provide her with the funds and support that she needs to fully modernize the library. And I would be happy to work with Ms. Lofgren and my friends across the aisle to help ensure that she receives those resources. It should be obvious that to bring the Copyright Office into the 21st century, we have to do more than just change the selection process for the register. It requires a massive overhaul of the IT system to create both a smoother process for creators seeking to protect their works and a system to enable the public to search the broad catalog of American creativity, and it requires greater accountability and consultation with both the creative and the user communities so that we ensure that the improvements and investments meet the needs of all of those who rely upon the Copyright Office to do its job well. I'm glad that the chairman has taken up this first step. I look forward to working with him, Ranking Member Conyers, and others on next steps as well, and I yield back the balance of my time.
Chair thanks the gentleman. For purpose of the gentleman from Tennessee, seek recognition.
Thank you, Mr. Chair. I just want to comment on
I was recognized for 5 minutes.
Thank you. I just want to comment on Mr. Deutsch's remarks. I appreciate Mr. Deutsch, but to suggest that just because many young people have never seen a card filing system you should condemn a card filing system. Many young people have never seen a newspaper. I don't think that was a fair jab.
Would you yield? Would you yield?
I yield.
Mr. Chairman, I've been yielded to.
You may proceed since you've been
Thank you.
yielded.
Thank you so very much. Let me acknowledge my friends and colleagues on the committee for the instructive comments that they have made. I particularly want to make sure that the competence of the present Librarian of Congress is elevated to the extent of recognizing that she had to persist in an extensive competition to be selected for this important position. Let me also acknowledge that she is beginning to make some sizable and important changes, recognizing the many stakeholders, not only in the Library of Congress, but in the Register. So this process is, as my ranking member has indicated and the chairman, is to elevate her status in the selection process and to be sure that her expertise is utilized. Again, as we sit here today, the Librarian of Congress is working. She is working on modernizing the library. She's working on responding to stakeholders. She's working on using better technology. And so I'm confident that as this legislation makes its way through the United States Congress, and any number of oversight opportunities will occur, we will have the right combination to ensure that we have the interests and the character of the institution that is preserved, that is the Office of the Register of Copyrights, and as well that we have the interests and character of the institution that is the Library of Congress. I think this amendment contributes to that balance, and I'd ask my colleagues again for their support, and I yield back.
Question occurs on the amendment offered by the gentlewoman from Texas. All those in favor respond by saying aye. Aye. Those opposed, no.
No.
Being the chair, the ayes have it, and the amendment is adopted. Are there further amendments? For purpose of the gentlewoman from California seek recognition.
I have an amendment at the desk, Lofgren Amendment Number 1.
Clerk will report the amendment.
Amendment to H.R. 1695 offered by Ms. Lofgren of California. Page 4, strike line 22.
Without objection, the amendment is considered as read, and the gentlewoman is recognized for 5 minutes on her amendment.
This amendment would delay the effective date when the librarian is removed as the appointing authority and it is transferred to the president. The date of September 5th, 2026 was selected because that's when Dr. Hayden's 10-year term is up. And I would just note something that I'll just say bothered me. We had Dr. Billington serve for decades and decades and decades, but it wasn't until a woman was appointed librarian that we put a term limit on the appointment. So that's just an aside. But there is a term limit now, and this would delay this change in the appointment authority till the end of her term. The library is making great progress on its modernization plans. Particularly, the current plan would result in saving significant amounts of time and money implementing the Copyright Office's information technology modernization plan and cost analysis. However, in order for this to work, a new register must be appointed in a timely fashion. Now, the library has hired Deloitte to review its plans. They expect a green light to start implementing modernization this September. Ideally, the register would be part of the review, but at a minimum, the register should be there when implementation starts this September. In other words, if this bill becomes law, we are actually voting to erase all the efficiency gains made by the library's hard work and careful planning, because we're not going to have a registrar by September. If this bill passes, we have no idea how long that seat will be vacant. But given that Bloomberg reports that this administration has yet to even nominate 495 Senate-confirmed positions, and only 20 have been confirmed so far, it doesn't look good. This, plus the time that it would take this measure to become law, if it does become law. Now, I mentioned earlier I serve on the House Administration Committee, which has jurisdiction over the library, and so I am privileged to get up-to-date library information. It may be that some of the Judiciary Committee members are hearing about the library's progress on the upgrade for the first time here. Had the committee bothered to bring Dr. Hayden in for a hearing or even a briefing, I wouldn't have to be the one to inform you. that we're in the middle of, marking up a bill that would set Copyright Office modernization back 2 years. This amendment allows the librarian to keep the authority to appoint the Register of Copyrights for her entire 10-year term. I think this is the only way to ensure a smooth and efficient modernization. And given her success in modernizing the Baltimore Library, I'd much rather trust this decision to someone like her who has a record of proven ability rather than the president, and it'll pile up with all the other decisions he has yet to make. So that is my amendment, Mr. Chairman, and I yield back.
Chair thanks the gentlewoman and recognizes himself in opposition to the amendment. This amendment delays the resolution of this important issue by 10 years. However, the vacancy that exists within the Registrar's office exists right now, not 10 years from now. There's no reason to wait to ensure that members of Congress and interested parties have input into who the next Registrar will be. This problem could have been avoided in the first place if the prior Registrar had not been forced out. She spent years working with us to identify copyright policy issues that needed this committee's attention, and I would say that notwithstanding the gentlewoman's contention that this will set back modernization, every single major copyright organization in America supports this bill. I urge my colleagues to oppose this amendment. Question occurs on the amendment offered by the gentlewoman from California. All those in favor respond by saying aye.
Aye.
Those opposed, no. No. Opinion of the chair, the noes have it, and the amendment is not agreed to.
Mr. Chairman,
What purpose the gentleman from California seek?
I'd now like to ask unanimous consent that the fiscal year 2017 budget for the Library of Congress be placed in the record.
Without objection, it will
Thank
be
you.
made a part of the record. What purpose the gentlewoman from California seek recognition?
I have an amendment at the desk, Lofgren Amendment Number 2.
The clerk will report the amendment.
Amendment to H.R. 1695 offered by Ms. Lofgren of California. Page 3, strike line 8.
Without objection, the amendment is considered as read, and the gentlewoman is recognized for 5 minutes on her amendment.
This amendment allows the Registrar of Copyrights to remove, the Librarian of Congress to remove the Registrar. This is an essential provision. How can you expect the librarian to, as mandated by law, properly supervise the Copyright Office when the Register is answerable to no one but the executive branch? And how do you truly supervise someone you can't fire? Now, what can the librarian do if a registrar is acting insubordinately or giving fake budget request numbers? Unfortunately, this is not a hypothetical. While preparing the fiscal year 18 appropriations request, the library noticed that a $25 million line item in the Copyright Office request didn't add up. When questioned about this, Registrar Polenti stated that this number was no big deal. It was just a placeholder, that they to make adjustments after the money was appropriated. In other words, the Copyright Office gave the librarian fake budget numbers with the intention that she go testify in front of the Appropriations Committee to the need of these funds that was made up. Additionally, the Inspector General report released last month regarding the Copyright Office's failed electronic licensing system said, and this is a direct quote, "Copyright executives at the time did not disclose in the library's performance management system and annual congressional budget justifications the magnitude of issues and cost." What does this mean in real language? The registrar hid the numbers. She hid the numbers from the librarian, and she hid the numbers from Congress. Without the ability to remove the register, the relationship between the librarian and the register is fundamentally altered. It will create uncertainty and ambiguity in the chain of command and unnecessary hurdles to the modernization effort. It creates a Sophie's choice for officers, employees of the Copyright Office. When there's conflict, who do they ultimately listen to? And again, this is not a hypothetical. Under the previous register, the Copyright Office CIO refused to recognize the library's CIO as a superior officer. This caused both availability and cybersecurity issues, some of which we can only be briefed on in classified settings. Under this bill, there is no right choice. It's a lose-lose for copyright employees. The only possible result of the change is more conflict between the library and the Copyright Office, not less. But that doesn't mean the register shouldn't have some kind of independence and protection, and that's why at a minimum, the librarian must be able to remove the register when it's warranted. And that is my amendment for accountability and good management, and I would yield back the balance of my time.
Chair thanks the gentlewoman and recognizes himself in opposition to the amendment. This amendment would recreate an existing problem that is being solved by the underlying legislation, the inherent tension between the Library of Congress and the U.S. Copyright Office. The Register of Congress should ultimately report to one individual, not two, and I urge my colleagues to reject the amendment.
Mr. Chairman,
For purposes, the gentleman from Maryland seek recognition.
move to strike the last word.
Gentleman is recognized for 5 minutes.
Mr. Chairman, I have very little familiarity with the Copyright Office, but I have some familiarity with the Constitution. And this amendment spotlights for me an underlying confusion, I think, that has run through all of the discussions we've been having. This amendment would vest the removal power in both the executive branch and in, I think, the legislative branch, to the extent we're characterizing the Librarian of Congress as someone who reports to Congress. So there's certainly no precedent for doing that, and I have grave doubts about its constitutionality. But at the same time, I was wondering, Mr. Chairman, and I would gladly yield to you or to Mr. Nadler, both of you in your opening statements referred to, I think in Mr. Nadler's case, direct accountability to Congress under the bill. And I'm wondering, is it contemplated that the President would appoint the Register of Copyright, but the Register of Copyright would still be a legislative branch official? And I think, Mr. Chairman, you analogized it to other congressional boards or officers. And so I'm just wondering, to the extent that we want to view this as the creation of an independent copyright register, is it under the legislative branch or under the executive branch? And I see the problem that that the gentlelady from California is trying to solve here. I don't think it's constitutional to vest it both in the executive branch and in the legislative branch at the same time.
Would the
If the gentleman would yield, I thank the gentleman for yielding. The fact of the matter is that the reference that I made to accountability to the Congress, it rests in the fact that the Senate must consent to a nomination made by the President of the United States. And with Ms. Jackson Lee's amendment, there would not only be that, but also, and there's precedent for this, there would be input by the Congress through the Speaker, the Majority-Minority Leader, and the President Pro Tem Majority-Minority Leaders in the Senate, and the librarian, input for the selection of the names submitted to the President to choose a nominee. So, but I share your concern about what I think recreates a problem in having both the President and the librarian able to terminate this employee. The whole purpose of this is to create greater autonomy for the register, and there still needs to be accountability, but I think it should be resting in one place in terms of terminating the employment. Unless, of course, this committee and the Congress has the impeachment power as well, but that is an entirely separate discussion.
Right. Reclaiming my time for a moment, Mr. Chairman, thank you very much. That's illuminating. You were essentially restating the constitutional baseline that that Congress will have its say through the advice and consent power in the appointment of the person. The last amendment we just adopted, of course, was for the non-binding submission of 3 individuals to the President. The President would not be bound by that, but presumably it would have some kind of persuasive influence in the process. And so I thank you for that clarification.
Would the gentleman yield?
I would gladly yield.
I would prefer, but given the underlying bill, I added the librarian rather than deleting the President. The PHH mortgage versus CFPB found that it's unconstitutional for Congress to restrict presidential removal of the FPB director to for cause only, distinguishing it from independent agencies governed by multiple board members. In other words, if an agency with executive powers is headed by a single director, the president must have unfettered removal authority and control. I think, though, but for management, it didn't deal with the issue of the ability of a manager to also have an opportunity to terminate. And I think based on the appointment that the presidential appointee makes away from the presidential appointee and creates still another, which I think is, will, for reasons I've indicated before, will seriously
power I've gotten since I joined the committee. But I gladly yield for 30 seconds to the member.
the concern that I have is when we're finally going to fix.
I think we just need to keep the analysis of separation of powers has been the removal power. And I think that this does, we are transferring the removal power from the Librarian of Congress to the president, and we're essentially making this an independent executive branch officer. And I think we need to keep the line straight if that's what we're going to do. I yield back, Mr. Chairman.
For the purpose of the gentleman from Georgia seek recognition.
I move to strike the last word, Mr. Chairman.
Gentleman's recognized for 5 minutes.
Mr. Chairman, in light of a lot of the work we've done on here, I just want to just come for just a moment, and especially my friend from California, to clarify that the Copyright Office under the previous administration, whether you liked her or didn't like her, did like the decision, didn't, to classify it as being as a disaster plea.
The gentleman,
I'll move right off it in the record.
no, it's not the whole report.
I would asking, I'll object to partial unless the whole report is actually.
I would be happy to have the whole report. I don't have it on me. It's very lengthy.
Without objection, the entire report will be made a part of the record.
Thank you.
Mr. Chairman,
And I,
For what purpose does the gentleman from...
at this time, I'd ask unanimous consent that the testimony on the 2017 budget by the copyright director on March 15, 2016 be placed in the record.
Without objection?
Additionally, I'd ask that the section or the entire April 14, 2016 budget for the County of Baltimore, which contains the $32 million budget for the library, the size of the library operation in Baltimore is $32 million. I'd ask that that be placed in the record, all or part. And we've already placed in the record the $3.7 billion.
We don't need unanimous consent request on that.
Thank you.
Without objection, those other things will be made a part of the record. The chair recognizes himself in opposition to the amendment. This amendment highlights an important issue facing any federal agency. Departments such as the Veterans Administration, the Office of Personnel Management have similar IT challenges. The USCIS, U.S. Citizenship and Immigration Services, faces problems with their outdated technology. The answer for any federal agency is to hire a qualified leader for the agency as a whole, who then hires the most qualified chief information officer they can find for the agency they head. The Register of Copyrights is in the best position to identify a fully committed IT professional dedicated to the necessary upgrade. In fact, the former Register already did by hiring their own chief information officer, whose role was subsequently marginalized within the library. I urge my colleagues to oppose this amendment. It would not be a good standard to impose on any appointment to any office in the government, other than an office that was directly a CIO office in and of itself. So let's not set a bad precedent here by imposing that requirement on this one office of the government.
Would the gentleman yield?
I'd be happy to yield.
I would just like to point out that although we all have opinions, the Inspector General specifically found that it was the Copyright Office that failed to implement the IT organization along standard and accepted practices, not the library, and I would yield back.
And so did the library.
Would the gentleman
Such
yield
a
as well?
failure.
Would the gentleman yield?
I would be happy to yield to the gentleman from Georgia.
Again, I agree with the chairman in disagreeing with this amendment, but for my friend from California, I think the concern I have here, and it's developed over into this amendment as well, I have just heard in just the last few moments that the former copyright registrar lied to Congress. That's actually an offense. But the IG, and I think the gentlelady would say, the IG made no criminal referral, no other aspect about this. I think if we want to have a hearing on the dismissal of the former copyright registrar, then we have that hearing, but that's not what we're here for. And if we're trying to back up the librarian's decision, then let's just make that plain, that we supported the librarian's decision. Some of us did not. But to make these categorical discussions and not give the entire issue here, I think is a concern. I'm for the most qualified person being there altogether. But I just wanted to point that out from the hearing of that. I yield back to the chairman.
Reclaiming my time, I want to say to the gentlewoman that we definitely recognize the importance of addressing the IT issues that exist in many places in our government, and the Copyright Office is certainly one. As I indicated earlier, that should certainly be a part of the copyright modernization legislation that we are working in a bipartisan fashion on in the committee, and we would welcome the gentlewoman's participation in that as well. But with regard to who is selected, experience in copyright for the Register of Copyright is mandatory. To further hamstring it with other requirements, and there could be many, I do not think is the right way to do it, but I would be happy to work with her once this legislation is complete and in law, work with the Speaker and the majority and the minority leader in the House and their counterparts in the Senate to make sure that this issue is highlighted and is going to be addressed by a new Register of Copyrights, but it should not be one of the two criteria for the selection process, and therefore I must oppose this amendment. The question, what purpose does the gentleman from Tennessee seek recognition?
Thank you, Mr. Chair. I seek recognition to show comedy with an M-O-T-Y, and I yield my time to Ms. Lofgren.
And I appreciate the courtesy, my colleague from Tennessee. You know, it's not always fun to talk about an inconvenient truth. But if you take a look at the U.S. Copyright Office annual budget requests as outlined on page 9 of the report that's now in the record, it points out, they didn't say lie, they just said it does not reflect the truth, another way of saying it's a lie. I think we need to have a manager who has integrity, obviously, but we also need to have a manager who has the capacity to run a large IT project. That should be, if this bill becomes law, and I hope and actually don't believe it will, the criteria for that, because it's not going to be a criteria that Dr. Hayden will be able to select, is going to be an important one. I understand that there are large organizations where you need to have computer processes. The Copyright Office is much smaller than the VA. The person in charge of the Copyright Office is the one who has the responsibility for modernization. We have a history of failure there, and if we don't put some criteria in, we're going to have continued failure there. So I thank the gentleman for yielding time and for allowing me to quote once again the Inspector General report, and I would yield back to the gracious Mr. Cohen.
What purpose does the gentleman from California seek recognition?
Strike the last word.
Gentleman is recognized for
Mr. Chairman, I would appreciate the opportunity to yield back my time.
The gentleman is afforded such an opportunity.
I yield back my time.
Sure, thanks, gentleman, and now recognize the gentleman from California.
Thank you both. The library recently made an attempt to solicit input into selection of a registrar via Survey Monday, a technique in which the whole public gets to go in. And I think the fact that this survey that the entire public has is what Congress is being offered in no small way typifies the way we're regarded currently by the library. Mr. Chairman, You never solve a problem by diminishing the office of the person who must solve it. The person who must solve it is not the librarian with a $3 billion+ budget. It is, in fact, whoever the successor is at the Copyright Office with a budget a fraction of that size, some sub $60 million. The reality is that Congress has underfunded the modernization of the the Trademark Office and has failed to empower this office. One of the things I'm going to be asking for in report language is to advise the new director to form an advisory board modeled after the PTO and thus make it a transparent process for stakeholders to be involved. There's no question at all, Mr. Chairman, I'm going to be voting for your bill as amended because to do nothing is to guarantee a continuation of the status quo. In closing, Mr. Chairman, I believe that we must worry about public interest and stakeholders. I believe that there is a record of failure, and I'm not going to cast aspersions on the record of failure except to say that this change is part of a process leading toward a selection of somebody who, by the way, is not being hired to be the CIO. That person is being hired to work with stakeholders, to find a way to outreach, to find out what the appropriate modernization is, and then oversee the person who, by the way, under FITARA, under the Federal IT Procurement Reform, is in fact the CIO. Budget authority now has shifted, and the important position is normally not the director as to IT, but that other position. Lastly, I do want to highlight that the scope of the librarian's past success is in millions of dollars, not billions of dollars. This is a dramatically larger job for her to take care of just the library, let alone the modernization of the copyright. So I think as we talk about whether or not, cards have been modernized properly, we're missing the point. The librarian has a huge budget and a huge responsibility, and no one is diminishing that today. But we oversee the copyright question, the modernization, and the accountability to this Congress and to the stakeholders. Your bill accomplishes a giant step toward that, which failure to do so would be the status quo. And with that, I yield back.
Question occurs on the amendment offered by the gentlewoman from California. All those in favor respond by saying aye.
Aye.
Those opposed, no.
No.
In the chair, the noes have it. The amendment is not agreed to. Are there further amendments to the bill? A reporting quorum being present, the question is on the motion to report the bill H.R. 1695 as amended favorably to the House. Those in favor respond by saying aye. Aye. Those opposed, no.
No.
The ayes have it.
I'd ask for your recorded vote, Mr. Chairman.
Board vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
Aye.
Mr. Goodlatte votes aye. Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Issa? Mr. Issa votes aye. Mr. King? Mr. Franks? Mr. Gomert? Mr. Jordan? Mr. Jordan votes yes. Mr. Poe? Mr. Poe votes yes. Mr. Chaffetz? Mr. Marino? Mr. Gowdy? Mr. Gowdy votes yes. Mr. Labrador? Mr. Farenthold? Mr. Collins? Mr. Collins votes yes. Mr. DeSantis? Mr. DeSantis votes yes. Mr. Buck? Mr. Buck votes yes. Mr. Ratcliffe? Mr. Ratcliffe votes yes. Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson votes yes. Mr. Biggs? Mr. Biggs votes aye. Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson Lee?
Aye.
Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline? Mr. Swalwell? Mr. Swalwell votes aye. Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Mr. Iapol? Mr. Iapol votes aye. Mr. Schneider? Mr. Schneider votes aye.
The gentleman from Texas, Mr. Farenthold.
Mr. Farenthold votes aye.
Gentleman from Texas, Mr. Gomert.
Mr. Gomert votes aye.
Gentleman from Arizona, Mr. Franks.
Mr. Franks votes aye.
Gentleman from Idaho, Mr. Labrador.
Mr. Labrador votes yes.
Gentleman from Florida, Ms. Deutsch.
Mr. Deutsch votes aye.
Gentlewoman from California, Ms. Bass.
Ms. Bass votes aye.
Has every member voted who wishes to vote?
What was Mr. Cicilline recorded?
Not recorded.
Okay.
The clerk will report.
Mr. Chairman, 27 members voted aye, 1 member voted no.
The ayes have it, and the bill as amended is ordered reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up House Resolution 184 for purposes of markup and move that the committee report the bill unfavorably to the House. The clerk will report the bill.
H.Res. 184, of inquiry requesting the President and directing the Attorney General to transmit respectively certain documents to the House of Representatives relating to communications with the government of Russia.
Without objection, the bill is considered as read and open for amendment at any time, and I'll begin by recognizing myself for an opening statement. Today, we consider the second and third resolutions of inquiry that have been referred to the Judiciary Committee this Congress. Pursuant to Rule 13, the rules of the House of Representatives, the committee must act on these resolutions within 14 legislative days of their introduction, or we could be discharged from our referrals on the resolutions. Accordingly, we have scheduled the resolutions for markup today in order to preserve our referrals. As I observed last month when the committee considered a similar resolution of inquiry, by scheduling these resolutions for consideration in committee, we are following what has been the practice in the House for the last 30 years, regardless of which party has been in control. In that time, over 75 resolutions of inquiry have been introduced in the House. Of those, only 2 were considered on the House floor, but even those 2 resolutions were marked up in committee. I believe that so few resolutions of inquiry are considered on the House floor because they have no effect on the executive branch's obligation to produce documents to Congress. Resolutions of inquiry are not subpoenas. Rather, resolutions of inquiry, if acted upon by the House, have no greater legal force or effect than sending the Attorney General or the President a letter requesting this information. The difference, though, is that sending a letter would not monopolize the committee's time. The first of the 2 resolutions we will consider today, House Resolution 184, was introduced on March 9th by Representatives Jeffries and Liu. I have moved that the committee report the resolution unfavorably. This resolution essentially seeks 2 types of information from the administration. First, it requests documents regarding whether then-Senator Sessions misled the Senate Judiciary Committee regarding his contacts with Russian officials during his confirmation to be Attorney General. Second, the resolution requests documents related to Russia's alleged interference in the 2016 presidential election. In regard to the request for documents related to the allegation that Attorney General Sessions misled the Senate Judiciary Committee, I believe that the resolution is wasting the committee's time. The Senate Judiciary Committee has looked at this matter, and Chairman Grassley has determined that Attorney General Sessions has cleared up any confusion regarding his testimony, and that the committee has no plans to ask him to return to the committee to explain himself further. As to the resolution's request for information regarding alleged ties between the Trump campaign and transition team and the Russian government, the investigations into these matters are ongoing, and it is inappropriate for this committee to seek documents related to those investigations at this time. In addition to the investigation that Director Comey confirmed last week that the FBI is conducting into this matter, both the House and Senate Intelligence Committees are also conducting investigations. Given the lack of any evidence of criminal wrongdoing, aside from the illegal disclosure of classified information, I think that the 3 existing investigations are sufficient and will not be aided by this resolution of inquiry. Our oversight efforts can and should be better than needlessly requesting information that is already available to those actually investigating this matter. There's no compelling reason for the House to act on this politically charged resolution of inquiry, and therefore I ask my colleagues to join me in voting to report this resolution unfavorably to the House. It's now my pleasure to recognize the ranking member of the committee for his opening statement.
Thank you, Mr. Chairman. Members of the committee, I support this resolution of inquiry, and I am going to take a few minutes to hope that you will join me. I think it's a very important matter. It's the responsibility of this committee to conduct oversight of the Office of the Attorney General and to ensure the independence and integrity of the Department of Justice. And so despite protests that this resolution is somehow not yet ripe, House Resolution 184 is the proper next step in exercising these responsibilities. Since the Attorney General took office, my colleagues, I have written to the department at least 6 times. We've asked for information about conflicts of interest, the Russia investigation, and reports of inappropriate contact between the White House and the Federal Bureau of Investigation. To date, we've received no response. We've also written to you, Chairman Goodlatte, on 2 occasions about related matters, and we've received no response there either. At our February markup of the Nadler resolution, both Chairman Goodlatte and Mr. Issa spoke at length about a letter they planned to send the Attorney General. It was described as the proper way to conduct oversight. We were promised an opportunity to join, but no letter to the Attorney General was ever sent. Instead, the majority wrote to the Federal Bureau of Investigation asking for a member briefing that still has not taken place. We did not learn of the letter until we read about it in the press. Our responsibility to this committee requires more of us, Mr. Chairman. House Resolution 184 is an opportunity to correct course and do our jobs. The resolution is also a chance to answer questions about the Attorney General's incorrect statements before the Senate. Some call them false statements before the Senate. House Resolution 184 asks for information about the Attorney General's meetings with Russian officials, his testimony before the Senate Judiciary Committee, and his later clarification of that testimony. This information is critical to understanding why Attorney General Sessions twice gave false testimony and whether his attempt to correct that false testimony is adequate. I find it hard to believe that Attorney General Sessions, at the time a sitting senator and an active member of the Trump campaign, was unaware of reports about the campaign's connections to the Russian government until he was asked about it in the committee room. I find it equally difficult to understand why Attorney General Sessions, in correcting his testimony, disclosed 2 meetings with the Russian ambassador, but not to a third that is clearly documented in the public record. Again, it is this committee's responsibility to ask these questions. We cannot and should not turn a blind eye to false testimony and an obviously incomplete record. House Resolution 184 is the right vehicle to begin that inquiry here in our committee. Finally, this resolution helps us address a larger problem, one that seems to sweep in more people in the president's orbit every single day. Why have so many of these men, each of them a part of the Trump campaign, met with the Russian government? And perhaps equally importantly, maybe more importantly, why have so many of these men attempted to hide these meetings from the public? To a character, it seems they have only come clean when the media has exposed their deception. I'm deeply disturbed by this pattern and what it might mean for our country. And in my time on this committee, Mr. Chairman, I've come to understand that certain values transcend party. These include faith in democracy, love of country, and respect for the Republican form of government guaranteed to us by our Constitution. These values are under attack, not just here, but around the world, by a regime that believes only that might makes right. We know that the government of Russia undermined our election. We know that they want to undermine the election of our allies. And given what we know, it is incumbent upon us to do something about it. And here is our chance to begin that work in earnest. I thank my colleagues, Mr. Jeffries and Mr. Liu, for introducing this resolution, and I urge my colleagues to listen carefully to the testimony that will follow and support House resolution. I thank the chair and yield back.
Mr. Chairman? Oh, he's got to go.
The chair now recognizes himself for the purposes of offering an amendment in the nature of a substitute, and the clerk will report the amendment.
Amendment in the nature of a substitute to H.R.S. 184 offered by Mr.
This is
Goodlatte.
yours, right?
Strike all that follows after the resolving clause and insert the following.
Without objection, the amendment will be considered as read, and I'll recognize myself to explain the amendment. I'm offering this substitute amendment to House Resolution 184 for 2 reasons. First, it clarifies the references to Attorney General Sessions in the underlying resolution. The resolution as introduced refers to Attorney General Sessions both before and after he was confirmed as Attorney General. Some of those references could use clarification, and I believe that my amendment makes the requisite temporal clarifications. Second, offering this substitute amendment preserves the majority's ability to ensure that the markup of this resolution proceeds smoothly and without dilatory tactics. Under the rules of the House, prior to conclusion of debate, the previous question can only be moved in order to proceed immediately to a vote on an amendment. By offering a substitute amendment today, the majority is reserving the right to exercise this procedural motion. Let me be clear. I do not believe that we will need to exercise this procedural motion. I intend to give members sufficient time to debate this resolution. However, offering this substitute preserves the ability to exercise this motion should the need arise. For purposes of the gentleman from New York seek recognition.
I move to strike the last word.
The gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. A resolution of inquiry is a high-level congressional request for information. Today, Representative Ted Lieu and I are requesting that the Attorney General, Jefferson Sessions, transmit information that relates to all meetings he had with Russian officials concerning the Trump campaign and matters of great national significance. At the heart of this resolution is a simple question. Why did a sitting United States senator mislead Congress about meeting with a foreign government that 17 of our intelligence agencies have concluded interfered with our election at the behest of Vladimir Putin in order to help Donald Trump win the presidency? The American people deserve to know. During his confirmation proceedings, then Senator Jeff Sessions testified and affirmed twice to his friends and colleagues in the Senate that he did not have communications with the Russian government in both oral and written form. On January 10th, he testified, "I have been called a surrogate at a time or two in that campaign, and I did not have communications with the Russians." A week later, Sessions responded to additional questions from Senator Leahy about his contacts with the Russian government with a categorical denial and a one-word answer, no. It wasn't until March 1st, after reports surfaced that Attorney General Sessions had at least 2 meetings involving the Russian ambassador, that he came forward to clarify, quote unquote, his testimony. On March 6, Jeff Sessions provided his supplementary answers to the Senate Judiciary Committee. He again maintained he did nothing wrong, boldly proclaiming in Trump-like fashion, "My answer was correct." Why did the nation's top law enforcement officer repeatedly give false testimony to Congress? The American people deserve to know. Now, unfortunately, Jeff Sessions is not the first Attorney General to mislead Congress under oath, but we should make sure that he is the last. In 1972, Richard Nixon nominated Richard Kleindienst to be the nation's Attorney General. During Kleindienst's Senate confirmation hearing, he asserted that no effort had been made by anyone at the White House to influence a major DOJ antitrust case. Later, secret Nixon tapes revealed that he had explicitly, the president, told Kleindienst to drop that very lawsuit. The Attorney General lied to Congress and ultimately pled guilty to committing a crime. How is the Jeff Sessions case any different? The American people deserve to know. Last week, the FBI director confirmed that there is an open criminal investigation into possible collusion between the Trump campaign and Putin's Russia. Along with Paul Manafort, Michael Flynn, Carter Page, and Roger Stone, Jeff Sessions was an integral part of the Trump campaign. In February of 2016, he became the first senator to formally endorse Donald Trump. A few days later, he was named chairman of Trump's National Security Advisory Committee. He was a frequent presence on the campaign trail. Did Jeff Sessions participate in possible collusion between the Trump campaign and Putin's Russia? The American people deserve to know. Before hooking up with Donald Trump, then Senator Sessions was quite clear on the systematic fraud and corruption in Putin's Russia. But something changed after joining the Trump team. And in March of last year, days after his official endorsement of Donald Trump, he said, "I think an argument can be made that there is no reason for the U.S. and Russia to be at this loggerheads. We ought to be able to break that logjam." Why did Jeff Sessions suddenly forget that Putin's brutal and corrupt regime undermines America's democratic values? The American people deserve to know. Now, the House is a separate and co-equal branch of government. We don't work for the Trump administration. We work for the American people. And the American people deserve to know if the Trump team colluded with Putin's Russia. That includes Jeff Sessions. Now, we now live in a world of alternative facts and fake news. That should trouble everyone. Apparently, it once troubled Jeff Sessions, and I close with this. He stated, "Finally, it is important to pause a moment to reflect on truth itself. I believe that we live in a created and ordered universe, that truth and falsehood are real. They are capable of being ascertained. I, Jeff Sessions, reject the doctrine of relativism that suggests everything is okay. We must always strive to hold the banner of truth high. Indeed, the pursuit of truth, wherever it leads, has been a hallmark of our civilization, and it is the single quality that has made us such a vibrant and productive nation. Well said, Jeff Sessions. Why have things changed now? Russian interference in our election, possibly aided and abetted by the Trump campaign, is not a Democratic issue or a Republican issue. It's an American issue. The truth is at the heart of this democracy. That's why this resolution of inquiry is necessary, and I urge that all of my colleagues vote in the affirmative.
The time of the gentleman has expired. For purposes, the gentleman from California seek recognition.
I move to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. The reason Representative Jeffries and I introduced this resolution of inquiry is because there's no greater issue facing our nation than to find out if there was collusion last year between the Trump campaign and Russia. At stake is the legitimacy of the current administration. Now, there are lots of different stories on Russia. It can be confusing to the public, so let me just boil it down to 3 simple things. We know that last year the Russians launched a massive cyber attack and influence campaign designed to undermine faith in U.S. elections, to hurt Secretary Clinton, to help Donald Trump. This is in an unclassified intelligence report that was supported by all 17 intelligence agencies. You can just search for it on the internet, type in unclassified intelligence report. It's the first thing that pops up. Other conclusions of this highly disturbing report also show that the Russians hacked multiple state electoral boards. So we know that happened. We also know now that there were numerous secret meetings between Trump campaign officials and the Russians that were not disclosed until the press disclosed them. And then third, we know that the Trump campaign benefited the Russians. There were articles last year showing how the Trump campaign went against every Republican national foreign security expert and took the pro-Russian position on Ukraine. We know that Trump campaign officials, even now, who are in administration, make pro-Russian statements. The president himself has made pro-Russian statements. So what we have here now is the Russians benefited the Trump campaign benefits Russia. So what looks like a quid pro quo could be explained by a number of reasons. It could be that the Trump campaign folks were innocent and naive and unwitting participants in what Russia was trying to do. It could be a nod, nod, wink, wink kind of thing, or it could be faux collusion. And that's what we need to find out. These documents will help us find that out. And if the White House wants to clear its name, it would want to release these documents. It will want this resolution of inquiry to succeed. If the White House has something to hide, it would want this resolution of inquiry to fail. It's also important to note that last week, CNN came out with a story that not only do we have smoke now, we now have evidence that U.S. officials have at their possession that may show actual coordination between members of the Trump campaign and Russian hackers. So now, in addition to smoke, we've got heat. And that's why this resolution of inquiry focuses not only on Jeff Sessions, but also on Trump campaign officials, including the president himself, Michael Flynn, Jared Kushner, Carter Page, J.D. Gordon, Richard Burt, Paul Manafort, Michael Cohen, and Roger Stone. We want to find out what information and what documents these folks transmitted, had in the possession, and what do these documents show about these secret meetings. The other thing that's important, separate and above from the Trump-Russia issue, is we do know that Jeff Sessions made a statement to Congress under oath that was not true. 2 former federal prosecutors in the Washington Post wrote an op-ed a few weeks ago saying that people have been indicted for far less things. So it's important to get the documents surrounding that untrue statement to find out what the preparation was that Jeff Sessions had before he made that statement, And it's important to understand that he didn't just sort of make an untrue statement under oath in any kind of hearing. This was a hearing where he was trying to get confirmed, which means that in his mind, it possibly may be that if he said something different, then maybe he might not have been confirmed, or maybe senators would have gone down a different path of inquiry. But he shut that off by making the untrue statement that he had no communications with the Russians. That's why we're introducing this resolution of inquiry. It's not to muck things up or slow things down with this committee. It's because we honestly believe, our caucus and Hakeem Jeffries and I, that this is the single most important issue that we ought to be focusing on now. And with that, I yield back.
Mr. Chairman.
Purpose of the gentleman from New York seek recognition.
Strike the last word.
Gentleman recognized for 5 minutes.
Mr. Chairman, there is an obvious cancer at the heart of the credibility and perhaps the legitimacy of the administration. That cancer consists of the whole question of relations with Russia. The administration is notably belligerent, truculent perhaps, to other countries, to our NATO allies, to China, to all kinds of countries, even Australia. But it fawns on Russia and Putin, and the question is why. We know that the Russians intervened in the last election with the goal of helping Trump's election. We know that there were numerous Trump campaign and administration officials in contact with the Russians prior to and during and after the campaign. We know that there's a pattern of these individuals first denying such contacts and then only when forced to admitting them. Mr. Flynn, Attorney General Sessions, Mr. Stone, who had to admit that he was in contact with Guccifer II, the public persona that the CIA says is a front for Russian military intelligence, which carried out some of the hacking. We know there was false testimony, deliberate or otherwise, by the Attorney General in front of the Senate. We know that although the President denies investments in Russia, he said he had no investments in Russia, we now know that there are lots of Russian investments in the Trump organization. His son, Donald Trump Jr. said a couple of years ago that a disproportionate share of the investment money in the Trump organization was from Russia, and money is flowing in from Russia, and that obviously can have a major influence. We know that there was a change in the Republican platform dealing with lethal aid to the Ukraine, engineered by the Trump campaign. We know that the Trump campaign denied that they had done this, and now we know who in the Trump campaign did the instruction to do this. We know that there's a criminal FBI investigation of possible collusion by the Trump campaign in the admitted Russian intervention in the campaign. We know all this. This obviously gives a lot of questions about the legitimacy of the administration and certainly about its credibility. We have a duty to solve that question, to remove this cancer. Now, we had a resolution of inquiry a few weeks ago that I introduced that dealt with a number of issues, the President's conflict of interest, the emoluments, and with any criminal or counterintelligence investigating targeting the President and various other named people, Michael Flynn, Paul Manafort, Carter Page, Roger Stone, etc. And the chairman deflected and opposed, and the Republicans on the committee opposed the amendment, opposed the resolution of inquiry, saying it was unnecessary because, after all, we ought to send a letter to get the same information. The letter was sent. The Democrats were not asked to sign it, but the letter was sent by the Republican members of the committee on March 8th. But the letter limited itself to requesting a briefing regarding Russia's alleged interference in the election and on alleged leaks. It did not have any reference to information about criminal counterintelligence investigations, investments by foreign government or foreign government entities in Trump entities. It had no reference to Trump's business dealings, etc. It did not, in fact, ask for the information that we were told it would ask for that made the request for the resolution of inquiry necessary. Now we have we have this spectacle of the chairman of the House Intelligence Committee conducting an obvious cover-up, although the Senate Intelligence Committee may be doing an honest investigation. So We need an honesty here. We need completeness here so the American people can be assured that there is not a cancer at the heart of the administration, that the administration works for it and not for Vladimir Putin. This resolution of inquiry, and I commend the sponsors, Mr. Jeffries and Mr. Liu, this resolution of inquiry asks for a part of this information. It asks for information regarding the contacts of the Attorney General, who falsely testified before Congress, maybe perjuriously, maybe not, depending on his intent and his state of mind, but certainly falsely testified before the Senate, admittedly. Asks for information about contacts between him and any representatives of the Russian government, and other various information regarding his testimony to the Senate. This is the least we should do. I urge the passage of this resolution of inquiry, but most of all, I urge the committee to conduct a proper inquiry, which starts with my resolution of inquiry, with this resolution of inquiry, with the next one that's coming up, and with other means that we have to ensure that this whole question, does the Trump administration have an undivided loyalty to the United States, or is there divided loyalties because of business interests, or for whatever reason, to Russia? That is a key question. I urge the passage of this resolution of inquiry. I commend Mr. Jeffries and Mr. Liu, and we have to start getting to the bottom of this.
Time of the gentleman.
Stopping collusion in a cover-up.
Time of the gentleman has
Thank you. I yield
expired.
back.
For what purpose does the gentleman from Texas seek recognition?
I rise to strike the last word.
Gentleman is recognized for 5 minutes.
Let me I rise to support the Jeffries and Liu resolution of inquiry, and I congratulate the gentlemen for their balanced and respected presentation of the facts. Mr. Chairman, we have had moments in this committee, and we have had many moments under your chairmanship. We've served together on this committee for more than the years that we might recall. And we've had some enormously bipartisan moments. We just finished 2 bills where there was a meeting of the minds. But enough is enough, and we're at that point. It is very difficult to conduct the business of this committee, to conduct the business of the United States Congress, when we are in the midst, if you will, of an unfolding inferno. Every day, there is a contributing factor to the collusion and the disarray of this government. The gentlemen have indicated certain points that I think are important. First, Attorney General Sessions has not fully explained his false testimony before the Senate Judiciary Committee. Second, the scope of the Attorney General's recusal from the matters related to his testimony may not be sufficient to address his ongoing conflicts of interest. Finally, the Attorney General is one of several individuals involved in the Trump campaign to have concealed his meetings with a representative of government. Recite for you the answer given to a question specifically given by Senator Franken during his confirmation hearings where he was under oath, which asked the question of his meetings or engagement with the Russian government. Senator Franken, this is Mr. Beauregard Sessions, I am not aware of any of those activities. I've been called a surrogate at a time or two in that campaign, and I did not have communications with the Russians, and I'm unable to comment on it. Colleagues, General Sessions was under oath. General Sessions is an informed, seasoned senator at that time that would have at least a general recognition and recollection that he had meetings, but he could not recall. The resolution gives a long list of questions, but questions remain. Why did the Attorney General give false and misleading testimony? Why is his explanation for that testimony incomplete? Is his recusal sufficient to address his ongoing relationship with President Trump? Why have so many individuals in President Trump's immediate orbit made contact with Russian government? Why have so many of them initially denied it? What is the involvement of Donald J. Trump, Michael Flynn, Jared Kushner, Carter Page, J.D. Gordon, Richard Burt, Paul Manafort, Roger Stone, or Michael Cohen? Paul Manafort has a long track record and a journey from Russia to Cyprus with dollars being either deposited or other questions arise. As I indicated, I've been here for Waco, several impeachment proceedings, including those of a federal judge. Crises are responded to by this holder of the Constitution. I want this to be done thoughtfully, quietly, and respectfully. The resolution before us by the two distinguished gentlemen from California and New York makes that point. But I think that we should not be fearful of the final question being asked, whether or not impeachment is the next step. This is not a frivolous statement. This is not a rush to judgment. It is a question of this committee as to whether or not we're going to allow our partisan positions to stand against a legitimate inquiry. This is a legitimate inquiry. I don't see the government functioning at all. We couldn't even come together on improving the Affordable Care Act or putting forward a legitimate substitute by members of Congress on how we will provide for the health care of our citizens. Why? We are stalled in this government. We are stymied in this government. We're overwhelmed in this government every single day. And finally, the acts that may break the camel's back. Former Deputy Attorney General Yates was headed to the United States Congress to tell the truth. What went on between January 26 to February 13? 17 days. What information was given? What information was covered up? We will not be able to function as a government of the people and for the people. And Barbara Jordan's words that were said in this committee some decades ago, when she said, "We the people." That is what this is about. Not my position, my party, not my district. It is about the American people. And if this committee refuses to investigate what is continuing to be a burning inferno, and one person after another stepping up and indicating that something is wrong, Mr. Chairman, with respect for your leadership and the ranking member's leadership and all of the members on this committee, we will be derelict in our duty. We will be abdicating our responsibility. We will be ignoring the Constitution. The facts must be followed, and the facts must lead us to the inevitable action that we must take. I yield back.
First, the gentleman from Tennessee seek recognition.
Strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chair. Former Vice President Joe Biden spoke recently and said the only thing bipartisan in Congress now is being against cancer. I'm not even sure if that's the case with the president's budget cutting nearly $6 billion from the National Institutes of Health. But there should be another area where we should be bipartisan, and that's our concern about Russia and their influence on our government and any influence on our president that might take away from his ability to fully support our country and our values. One of my predecessors was a man named Dan Kirkendall. He served in this House. Mr. Conyers might remember him. He served in this House from 1966 to 1974. And in about 73, he spoke on the floor of the House and held a noose up when he spoke. And he said that the Democrats were trying to hang Richard Nixon. He was one of the most ardent supporters of Richard Nixon in saying that the Democrats were wrong to take him on concerning breaking into the Watergate. Harold Ford Sr. used that picture, and because of that picture and other reasons, Dan Kirkendall was defeated in 1974, and that was the Watergate year with one of the greatest Democratic Congresses elected ever. Because the American people knew that Nixon had violated the law, they knew the Democrats were correct, and they knew the Republicans were wrong to stand beside this man who was a law violator and had not upheld his oath of office. We are at a situation to where my colleagues and friends on the Republican side, and I know from talking to many of them, have concerns about this relationship with Russia. What we see with $45 million resorts in Palm Beach being purchased by Donald Trump and then being sold within a year or 2 years to a Russian fertilizer king for $95 million, and where we read about straw parties owning condos in Trump Tower, where we don't know who really owns them, and how that has been used by Paul Manafort and others in New York real estate markets to launder money into our country by people from Russia and purchasing assets in New York City and apparently Palm Beach, and using a bank in Cyprus for which the co-chair was our present Secretary of Commerce. That's where the financing of the Palm Beach house went. I know my Republican friends and colleagues are concerned about this as well, but they're constrained by the fact that this would involve the Republican president. If you want to do that, you do that. But history says you're doing it at your own risk and your own political life. If you want to go the way Dan Kirkendall went, stick with this position and don't allow inquiries. But somebody needs to stand up on the Republican side, other than Walter Jones, who I consider heroic, who has been described by some Republican journalists as being idiosyncratic. I look at him as being honest and voting to see Trump's tax returns, and honest in saying that Mr. Nunes cannot continue to lead that investigation as a person who's gone beyond party politics, which he often has, and spoken the truth, which he's heard from his people, and trying to set this country right. And somebody needs to speak for what Dwight Eisenhower would say about this, and what Ronald Reagan, who called Russia the evil empire, and it's just as evil today as it was then, and what Barry Goldwater would say about this. I can't think of any Republican leader. John McCain has come out and questioned it. Lindsey Graham has questioned it. Most Republican journalists of a moderate persuasion have questioned it and said that this is something that needs to be looked into and responded to. If we are subject to Russian influence, we need to know it. And if we're not, the White House needs to be cleared. Either way, we need to act, and this committee can show leadership. Congress's reputation is even worse than it was when it was at the 16-point level, and it's going further down and down when we continue to look like ostriches putting our heads in the sand and not facing the real issue, the red scare that's out there, the red menace that apparently has an influence over the White House. I yield back the balance of my time.
Let's see, time and the other to me. Okay. For what purpose does the gentleman from Georgia seek recognition?
Move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. This committee has been very much involved during the last administration in a number of investigations. The fast and furious investigation of involvement of the ATF in arms that were lost and then used in the killing of a DEA agent in Mexico during a drug enforcement raid. This committee looked into that, delved into that, even got to the point where I believe held the Attorney General in contempt of this committee for allegedly giving false information, as I recall correctly. So this panel, this committee has looked into that, looked into the IRS, tried to make it a scandal about Lois Lerner, tried to have Lois Lerner criminally charged, was in the process of trying to impeach the IRS commissioner, all during the last administration, the Democratic administration. It investigated Benghazi. You know, this committee has done a lot of oversight in the past, but it confuses me to think that now, when there's when the facts cry out for an investigation of the Trump campaign, the Trump administration, Attorney General Jefferson Beauregard Sessions, when it comes to a resolution of inquiry about anything having to do with the Trump administration, this committee is reluctant to move. What is the reason for that? My colleagues have explained the cause that is here for us to delve into Jefferson Beauregard Sessions' statements, which appear to be false, made to the Senate. This resolution just simply asks the executive branch, the president and the attorney general, to supply certain documents that would be germane to this committee looking into this issue. After all, the Judiciary Committee is charged with overseeing the administration of justice with respect to federal courts and administrative agencies, including the Department of Justice. This is within our bailiwick. This is something that we should be investigating. Why is it that any member of this panel would refuse to support the Jeffries resolution, the Jeffries-Liu resolution of inquiry, which I'm rising to state my support of? Why would anybody be opposed to that? Simply gathering information from the executive branch upon which there may lie cause to proceed with a full-blown investigation by this committee. But without the documentation, the committee has no way of knowing whether or not there should be an inquiry. And so failing and refusing to support this resolution is like a ostrich putting its head in the sand, not wanting to see what the documentation reveals. And so I think it is incumbent upon this committee to support the the Jeffries-Liu resolution of inquiry. It's the right thing to do for this committee. It's the right thing to do for the American people. And if we don't support this resolution, then it shows the American people that politics trumps, and no pun intended, politics trumps the truth. And the truth has been being battered since January 20th. The truth has been battered, beaten, and bruised. Will the truth survive for the next 4 years under this administration? That's the question that we must answer. I ask my colleagues, I beg my colleagues.
Time of the gentleman has expired.
This
Who seeks
resolution,
recognition?
and with that, I yield back.
For purpose of the gentleman from Rhode Island, seek recognition.
I move to strike the last word, Mr. Chairman.
Gentleman's recognized for 5 minutes.
Mr. Chairman, Democrats and Republicans can have differences on public policy, but I know there's no difference in our love of our country and our commitment to protect our democracy, particularly to protect our democracy from foreign adversaries. And I know that we all will always put our country ahead of our political party. And so I implore my Republican colleagues to support this resolution, and I really want to thank and acknowledge the extraordinary leadership of Mr. Jeffries and Mr. Liu for bringing forward this resolution. And I think history is going to judge very harshly those who refuse to demand that we follow the facts and get to the bottom of all of this. So what are the facts? Attorney General Jeff Sessions was asked twice about his contacts with Russian officials during his confirmation hearing in January 2017. Both times he failed to acknowledge meetings he had with Russia's ambassador to the United States. In a written questionnaire, he also said, in response to a question, had he been in contact with the Russian government about the 2016 election before or after Election Day, and he gave the answer no. When asked by Senator Franken about the Kremlin's ties to the Trump campaign. He said, "I've been called a surrogate at a time or two in the campaign, but I did not have communications with the Russians, and I'm unable to comment on it." The truth is, we know that Senator Sessions was more than just one of many Trump campaign surrogates. He was the first sitting United States Senator to endorse Donald Trump for president. He served as chairman of the campaign's National Security Advisory Committee. But contrary to his sworn statements to Congress, we've recently learned that Senator Sessions did meet with Russian Ambassador Sergei Kislyak twice during the presidential campaign. He later claimed that these meetings only took place as part of his work on the Senate Armed Services Committee. But you know, facts are stubborn things. The truth is, the first of these meetings took place at last year's Republican National Convention, where Sessions attended as a surrogate for the Trump campaign. His political campaign fund paid for the expenses at the convention. These were clearly beyond the scope of his responsibilities as a United States Senator. The next meeting we know took place on September 8th at Senator Sessions' office. I'm concerned about these because in addition to withholding these meetings from public scrutiny, Attorney General Sessions has apparently had a real change of heart about American foreign policy toward Russia. In 2008, following acts of Russian aggression in Georgia, then Senator Sessions spoke on the Senate floor saying, "Russia's recent actions in Georgia remind us that this country might be seeking to restore old Soviet ideas of dominance throughout their neighbors and in Eastern Europe, all of which should serve as motivation to move ahead with the necessary capabilities to defend ourselves and our allies from missile attack." Then in 2010, he voted against the New START treaty, saying, "I'm deeply disappointed the Russians have been so intransigent, hard-headed about this treaty and other relations with the United States. If they have nothing to hide, what's going on here?" And then in 2014, following more acts of Russian aggression in Ukraine and Georgia, Senator Sessions called for deep sanctions, saying that a systematic effort should be undertaken so that Russia feels pain for this. And again in 2015, before Donald Trump was a candidate for president, before Russia released hacked documents for the Democratic National Committee and John Podesta, Senator Sessions again argued for sanctions, saying it needs to be clear that Russia knows that there will be a high price to pay if their behavior continues. But 1 year later, in March of 2016, shortly after he endorsed Donald Trump, Senator Sessions started seeing eye to eye with the Kremlin, saying, and I quote, "I think an argument can be made that there's no reason for the U.S. and Russia to be at this loggerheads. Somehow, some way, we ought to be able to break that logjam." And then in July of last year, he said, "The big issue is should we be able to create a new and positive relationship with Russia?" This is quite a change of heart. More and more comes out each day about this administration's ties to Vladimir Putin's regime. We've learned that Jared Kushner, Michael Flynn, Carter Page, and Jay Gordon have all met with Ambassador Kislyak. But given that President Trump is still refusing to disclose his tax returns, we're still in the dark about the full extent of these connections. This all raises questions we need to urgently answer. Why did Sessions fail to tell the whole truth during his confirmation hearing? What did he discuss with the ambassador? How is it that a senator with 20 years of experience on the Armed Services Committee all of a sudden became a dove towards one of our most hostile adversaries? This is not something I take lightly. The Attorney General has to be held to a higher standard. We must get this information. This resolution is an important step to understanding the connections between the Attorney General, this administration, and Putin's Russia. I urge my colleagues, I beg my colleagues, I implore my colleagues to support this amendment and help us get to the bottom of this. The American people deserve answers. And with that, I yield back.
Time of the gentleman has expired.
Mr. Chairman,
For what purpose does the gentleman from California seek recognition?
Mr. Chairman, I move to strike the last word.
Gentleman's recognized for 5 minutes.
Mr. Chairman, this past election, our democracy was attacked, and our nation's leaders are failing to do our job to find out just exactly how that happened, whether any U.S. persons were responsible, and most importantly, what can we do to make sure we're never in a mess like this again? Because regardless of what side you're on this debate, I'm sure everyone agrees Russia is winning. They're winning right now. They're celebrating the discord and divide in our country. This is exactly what they intended to do. And so people at home, our constituents, they're asking, what are you going to do about it? Are you going to let this attack go unanswered? Are you going to allow people who were involved to not be held accountable? Or will you show leadership? Unfortunately, right now, the House Intelligence Committee's investigation is stalled. We were going down a bipartisan investigative road together. We had a productive week last week when we had an open hearing for the FBI director and Admiral Rogers. We learned about dots that continued to connect Donald Trump, his family, his businesses, and his campaigns, personal, political, and financial ties to Russia that were converging at the same time with Russia's interference in our campaign. This evidence, our concerns, were validated by the FBI director confirming that there were counterintelligence and criminal investigations into the president's campaign. Unfortunately, our chairman exited that bipartisan road, and our investigation is stalled. But as members of the Judiciary Committee, we have an opportunity right now to do a small piece of this investigation to understand why, when asked under oath, the Attorney General misled his Senate confirmation panel about prior contacts with Russia. And perhaps just one person in the administration misleading about prior contacts with Russia could be excused with an innocent explanation. I think we're all willing to accept that. However, when you put this in context, you do not see coincidences, you see a pattern of deception. You see the National Security Advisor, Michael Flynn, who lied to the Vice President about his prior contacts with Russia as he was trying to wink and nod that the U.S. policy of sanctions toward Russia would be changed. You see Jared Kushner not disclosing that during his time as a transition team member, and also somebody still associated with Kushner Properties, he was meeting with a sanctioned Russian bank, something that was only disclosed this week when he was asked to provide testimony to the Senate Intelligence Committee. And most disturbing is the President of the United States accused our former president of wiretapping him, a deceitful claim that has been repudiated across the board by every intelligence official who'd have access to his claim. So when you put all of this together, you don't have coincidences. You have a pattern. And what this committee should seek to do is to understand, what does that pattern mean? How does it relate to the attack we saw in our past election? Every jury in America and every courtroom in America is told that if a witness deliberately lies about an important fact in an investigation, you can use that not only as a consciousness of guilt, but you can choose not to believe anything that person says with respect to the investigation. We have a lot of questions for people associated with Donald Trump and his campaign and their ties to Russia, and their ties that are followed by deceit about those ties. And so it's our committee's responsibility to get to the bottom of that. And as Mr. Cicilline said, we have a model of this. After September 11th, our country was attacked. Republicans and Democrats united on the Capitol steps. Arm in arm, they sang, "God Bless America." But what they did after was even more important than that moment of unity. They went to work. They put politics aside. They made important reforms to make sure we'd never be attacked in the skies again, and they had a parallel independent commission. We have a model of how we can work together when our country's attacked, and I hope my colleagues on the other side join us, and I yield back.
Mr. Chairman.
For what purpose does the gentlewoman from Washington seek recognition?
Move to strike the last word, Mr. Chairman.
The woman is recognized for 5 minutes.
Thank you. I'm very proud to rise in strong support of my colleagues, Representative Jeffries and Representative Liu's resolution today, and I thank them for offering this. I do believe that our democracy faces a crisis of trust. We have the American people unsure of who and what to believe, unsure of whether we in Congress are taking our responsibilities of accountability seriously, and the reality of numerous reports every day. It's difficult to go to sleep at night and know what you're going to wake up to. You feel as if a whole news cycle of 30 days has proceeded in the course of 5 or 6 hours. And I think the big questions right now are, when we see people lying under oath, such as the Attorney General, in whose interest are they operating? Why would they lie about connections or conversations with the Russian government. We're not necessarily saying that nobody should have any kind of a conversation, but when somebody lies under oath and perjures themselves, you have to wonder why. And what is being promised or offered in those conversations that people choose not to share what they spoke about. And we've heard, through my colleagues on this committee, the numerous occasions in which Jeff Sessions, in his Senate confirmation process, had a couple of opportunities to set the record straight, and he didn't take any of those. When he told Senator Franken that he was, quote, not aware of any of the Trump campaign's communications with Russia, and he even specifically mentioned that he served as a Trump campaign surrogate, but said, quote, I did not have communications with the Russians. And then later, 1 week later, in writing, he reiterated this position in response to a question from Senator Leahy directly about whether he or anyone, whether he himself had contact with anyone connected to any part of the Russian government, and his response was just one word, no. As a lawyer and a long-term member of Congress who has participated in many confirmation hearings, Jeff Sessions should know better, and indeed, he does know better. And these are all quotes from 1999 from Jeff Sessions. As United States Attorney, this is a quote, as United States Attorney, it was my decision whether an officer who had told a plain lie under oath, even a young officer, should be prosecuted in order to preserve the rule of law and the integrity of the system. Here's another one. As one who loves the law and who has spent the better part of his professional career trying cases, I understand in a profound way just how important it is for justice that citizens tell the truth in court. He went on to say, as a federal prosecutor, I presented thousands of cases to a grand jury and tried hundreds. On many occasions, I have seen witnesses tell the truth, even when it was very painful for them. Such integrity is a source of great strength for our country. The rule of law and the need for integrity in our justice system is why perjury cases are prosecuted in America. Another quote, I have no doubt that perjury qualifies under the Constitution as a high crime. It goes to the heart of the judicial system. Mr. Chairman, I'm deeply disturbed that this man, who clearly understands the seriousness of perjury, or at least did until he was up for confirmation, and now in his position as Attorney General, would now refuse to tell the truth. How can we expect such a person to serve as our nation's top prosecutor? And what do we tell our children about the importance of telling the truth when the top law enforcement officer of this country does not feel the need himself to tell the truth? Now, we've seen...
Gentlewoman from Washington, yield.
I would like to take a few more seconds of my time to finish my statement, and then I'd be happy to yield, Mr. Chairman.
Okay.
Thank you. We have seen time and time again how the president and his associates have repeatedly denied any wrongdoing when it comes to Russia. We've heard about Michael Flynn, Jared Kushner, Carter Page, and Roger Stone. And I hope that this Attorney General's conduct would be concerning to all. This resolution just asks for information, and I hope that we would, in a bipartisan way, agree to that. Mr. Chairman, I yield for your question.
Without objection, the gentlewoman will be given an additional minute. Does the gentlewoman from Washington recall what this committee impeached President Clinton for?
Mr. Chairman, I'm sure that you recall it since you would like to inform the courtroom or inform the audience of that, so please go ahead.
Well, he was impeached for grand jury perjury and also for civil deposition perjury. The grand jury perjury went to the Senate. The civil deposition perjury count was not approved by the House, but after the impeachment was all over with, the presiding judge at the deposition found that the president had not told the truth and ordered him to pay $90,000 to the plaintiff in that case and sent a certification to the Arkansas Supreme Court, which I believe disbarred him for that.
Mr. Chairman, if I could respond with an additional minute, if you would grant me that.
Of course, without objection.
Thank you so much, Mr.
gets an
Chairman.
additional minute.
I assume that that means that you would be in support then of this resolution, because in fact, this resolution is going to the point of what I believe you were trying to get at, which is that people impeached President Clinton or didn't vote for that, which I assume you're saying was not a good thing if somebody voted against that impeachment. So I believe that we are here to do the right thing. And if you believe, too, that when somebody lies under oath, it is in fact a perjury that we should take seriously, then I would ask you, Mr. Chairman, if you plan to vote for this resolution.
I intend to vote to report the resolution adversely.
I was hoping, Mr. Chairman, that given your question, which set up perfectly my response, that you would now say that you are on board in a bipartisan way with Mr. Jeffries and Mr. Liu's resolution that would actually hold us in Congress accountable for holding people accountable if they do not tell the truth,
Well, if the
especially in a confirmation.
gentlewoman will yield again, this resolution doesn't seem to be very bipartisan. I would urge her as a new member, if you want to get things passed, make them bipartisan.
Will the gentleman yield?
The time belongs to the gentlewoman from Washington, which has expired. For what purpose does the gentleman from Florida seek?
Move to strike the last word, Mr. Chairman.
Gentleman is recognized for 5 minutes.
Mr. Chairman, your suggestion that the failure to have bipartisan support for this resolution is somehow the fault of my friend from Washington, I think is not only unfair to her, but really raises the fundamental problem that this committee is struggling with. In fact, it raises the fundamental problem that the House is struggling with. The last time we had a hearing like this with a markup, Mr. Chairman, on a similar resolution to ask for additional information that would help us better understand the serious concerns that we have about what happened before the election and since with respect to the Trump campaign and the White House. We were told, as I recall in that hearing, that this was somehow about political gamesmanship, that we were told, I believe one of our colleagues from across the aisle suggested that we were still working through the stages of grief. Our mental state was questioned at that markup, as I recall. And, Mr. Chairman, the fact is that there has been nothing that has transpired since that last markup that has done anything other than further bolster the need for us to get the information that the American people need to have. And with that, Mr. Chairman, I'd like to yield some time to my friend from New York, Mr. Jeffries.
I thank the distinguished gentleman from Florida for his very eloquent remarks. And, you know, Mr. Chairman, for the life of me, I haven't been able to figure out why we haven't been able to secure bipartisan cooperation on what is really simply just a search for the truth. This is not an article of impeachment. I don't really understand the comparison to what took place with President William Jefferson Clinton. This is not even a censure resolution, which somehow House Republicans thought was appropriate based on their disdain for the great Attorney General Eric Holder. This is a resolution of inquiry, anchored in the fact that we actually have an ongoing criminal investigation into potential collusion between Putin's Russia and folks on the Trump campaign. Were these actually low-level volunteer intern types, as someone from the White House seemed to suggest? No. At the same time, that 17 different intelligence agencies concluded that Russia was interfering with our election for the purpose of helping Donald Trump. High-level Trump cronies were having conversations with Russian intelligence operatives. Who were those individuals? Michael Cohen, his personal lawyer. Jared Kushner, his son-in-law and senior White House advisor. Paul Manafort, the campaign chairman. Jeff Sessions, his future attorney general. Michael Flynn, his national security advisor. Roger Stone, all of us from New York know, a close friend and ally of Donald Trump. Carter Page, his top foreign policy advisor, all having conversations at the same time that 17 different intelligence agencies concluded Russia was hacking into our election. Is this a politically charged resolution of inquiry? Or is it a search for the truth where we would welcome bipartisan cooperation? We can't even figure out, why is Donald Trump hiding his taxes, the first president since Richard Nixon to do so? Why in the world won't Donald Trump say a negative thing about Vladimir Putin, who I think my friends on the other side of the aisle understand is a thug and a dictator? He says a negative word about all of our allies, Britain, France, Australia, Mexico, NATO, the European Union. He can't say a negative thing about Vladimir Putin. In fact, he suggests that there's a moral equivalence between Putin's brutal regime and the United States of America to, of all people, Bill O'Reilly on Fox News. Now, I would suggest that we are in the midst of an epic struggle between authoritarianism and democracy. We defeated communism and proved that capitalism was more resilient. And I would just urge all of my colleagues on the other side of the aisle to help us make sure that democracy defeats authoritarianism this time around. I yield back.
What purpose does the gentleman from Texas seek recognition?
I have an amendment at the desk.
Clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.Res. 184 offered by Mr. Gohmert of Texas. Page 3.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. Since we are quite concerned now, as many of us have been, about Russia for decades, I'm thrilled with the newfound concern about Russia from my colleagues across the aisle. Some of us, and though I'd been an exchange student for a summer to the real Soviet Union back in the day, and many years ago spoke some Russian, I did learn from that trip there was plenty to be concerned about with the Russians. And so there was an article from, of all places, the New York Times. It's not always the bastion of truthfulness these days, but this article from April 23rd, 2015, Joe Becker and Mike McIntyre had asked to be made part of the record. At the heart, it says, at the heart of the tale are several men, leaders of the Canadian mining industry, who have been major donors to charitable endeavors of former President Bill Clinton and his family. Members of that group built, financed, and eventually sold off to the Russians a company that would become known as Uranium One. Beyond mines in Kazakhstan that are among the most lucrative in the world, the sale gave the Russians control of 1/5 of all uranium production capacity in the United States. Since uranium is considered a strategic asset with implications for national security, the deal had to be approved by a committee composed of representatives from a number of United States government agencies, not Congress, but agencies. Among the agencies that eventually signed off was the State Department, headed by Mr. Clinton's wife, Hillary Rodham Clinton. As the Russians gradually assumed control of Uranium One in 3 separate transactions from 2009 to 2013, Canadian records show a flow of cash made its way to the Clinton Foundation. Uranium One's chairman used his family foundation to make 4 donations totaling $2.35 million. Those contributions were not publicly disclosed by the Clintons, despite an agreement Mrs. Clinton had struck with the Obama White House to publicly identify all donors. Other people with ties to the company made donations as well. It goes on to say, at the time both Rosatom and the United States government made promises intended to ease concerns about ceding control of the company's assets to the Russians. Those promises have been repeatedly broken, records show. It goes on further to say, when the Uranium One deal was approved, that's Ms. Clinton's State Department approved the deal, The geopolitical backdrop was far different from today. The Obama administration was seeking to reset strained relations with Russia. So it wasn't the Trumps that went over and belittled the Bush administration's adverse reaction and principled stand against Russia's assault on Georgia. That was a principled stand by the George W. Bush administration, which was completely belied and besmirched by the State Department Secretary Hillary Clinton, and saying we want to reset the relationship, even though they didn't know the word for reset. But the deal in the article said the deal was strategically important to Mr. Putin, who shortly after the Americans gave their blessing, meaning the Secretary Clinton, sat down for a staged interview with Rosatom's chief executive, Sergei Korenyakov, who said, few could have imagined in the past we would own 20% of U.S. reserves. He told Mr. Putin, that is Russia owning our reserves. So the article is quite telling, and there's massive amounts of money that enriched the Clinton Foundation and the Clintons. And I also want us not to forget that it was this committee that still has not heard back from the United States Attorney for the District of Columbia on Secretary Clinton's sworn testimony in which she clearly perjured herself regarding her use of a private email server. So these are very, very disturbing developments. I'm very pleased that my colleagues across the aisle are now concerned about Russia, possibly as much as I have been for much of my life. And I would ask that this amendment may be made part of the amendment to the amendment in the nature of a substitute so that we can get to the bottom of it. And I yield back.
Would the gentleman yield? Would the gentleman yield?
I'll yield to the chairman.
chair? And without objection, the chair would be happy to recognize the gentleman for 2 additional minutes, so he can also yield to the. First of all, I appreciate the gentleman's amendment, but the problem is that a resolution of inquiry is an inappropriate and really ineffective method for conducting effective oversight. That's why I oppose the underlying resolution. It's why I will vote to report it unfavorably, and I encourage my colleagues to do the same. And I'm happy to work with the gentleman from Texas, however, on his specific concern as this committee moves forward with its oversight work. And I think his concerns are legitimate, and as the gentleman knows, I share them. Despite our efforts, this committee has never had a full accounting of the Clinton Foundation's work and its foreign contacts. If the gentleman would agree to withdraw the amendment, I would be happy to continue working with him to address those concerns and any others he has through legitimate means of congressional oversight. Now, let me add to that, because folks on the other side have said, we're not doing anything. That's not true. First of all, at the last resolution of inquiry considered by this committee, both the minority and the majority sent letters to the Justice Department. Following the sending of that letter, the ranking member and the chair were briefed in a classified setting by the director with regard to the issues at hand in that resolution, which are very similar to the ones in this one. And while I cannot disclose the classified information discussed in that briefing, I can say that the following Monday, a hearing was held in the House Intelligence Committee at which the director publicly confirmed that an investigation is ongoing into some of the matters that are the subject of this. Secondly, the offense that occurred here, unlike when the former Attorney General, Mr. Holder, came before this committee and testified, and his testimony was questioned, the offense occurred in the Senate Judiciary Committee, and the Attorney General has since clarified his statements, and the Senate Judiciary Committee has said, we're not going to pursue this any further. At the same time, the Intelligence Committee in the House and the Intelligence Committee in the Senate are conducting investigations, and that is a strong indication that this matter is being pursued both by the administration and by the legislative branch. So I do not see any point to this resolution of inquiry other than as a fishing expedition for political purposes, and that is why I will vote to report it unfavorably. But if the gentleman would withdraw.
And Mr. Chairman, I know you to be a man of your word. You give me your word. You will work with us in pursuing the basis for my amendment, and with that basis, I will withdraw the amendment. And thanks, Chairman.
Gentlemen. Does the gentleman? Okay.
Mr. Chairman, did you make the article a part of the record?
I will make that, without objection, that will be made a part of the record.
Thank you.
Who seeks recognition? The question occurs on the amendment in the nature of a substitute offered by the chair. All those in favor respond by saying aye. Aye. Those opposed, no. The amendment in the nature of substitute is agreed to. A reporting quorum being present, the question is on the motion to report the bill.
Did we get a roll?
Is it 203? Nope. Here it is. A reporting quorum being present, the question is on the motion to report the bill H.Res. 184 as amended unfavorably to the House. Those in favor will say aye. Aye. Those opposed, no. No. The ayes have it, and the bill as amended is ordered reported unfavorably. A recorded vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
Aye.
Mr. Goodlatte votes aye. Mr. Sensenbrenner? Mr. Sensenbrenner votes aye. Mr. Smith? Mr. Shabbat? Mr. Isa? Mr. King? Mr. Franks? Mr. Franks votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Jordan? Mr. Poe? Mr. Chaffetz? Mr. Chaffetz votes aye. Mr. Marino? Mr. Gowdy? Mr. Labrador? Mr. Farenthold? Mr. Collins? Mr. Collins votes aye. Mr. DeSantis? Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Mr. Ratcliffe votes yes. Ms. Roby? Ms. Roby votes aye. Mr. Gates? Mr. Gates votes aye. Mr. Johnson of Louisiana? Mr. Johnson votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. Conyers?
No.
Mr. Conyers votes no. Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Cohen votes no. Mr. Johnson of Georgia? Mr. Deutsch? Mr. Deutsch votes no. Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Jeffries votes no. Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? Mr. Liu? Mr. Swalwell votes no. Mr. Liu? Mr. Liu votes no. Mr. Raskin? Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Mr. Schneider? Mr. Schneider votes no.
The gentleman from Idaho.
Mr. Labrador votes yes.
Gentleman from Utah. Gentleman from South Carolina.
Mr. Gowdy votes yes.
Gentleman from, the gentleman from Ohio.
Mr. Jordan votes yes.
Has the gentleman from Texas, Mr. Ratcliffe, voted? Okay. The clerk will report.
Mr. Chairman. Mr. Chairman.
What purpose the gentleman from New York seek recognition?
Ask how I'm recorded.
Gentleman is recorded as a no.
Thank you very much.
Gentleman from New York is recorded as a no. Gentleman from Rhode Island is recorded as a no.
Mr. Chairman, 15 members voted aye, 11 members voted no.
The ayes have it, and the bill as amended is ordered reported unfavorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments and staff is authorized to make technical and conforming changes. The committee is advised that there is a vote on the floor of the House with 12 minutes remaining, but we do have one more resolution of inquiry. What's that?
We're not going to finish it in 12 minutes.
So the committee will proceed with opening statements on that, and then we will reconvene following the last vote in this series. So pursuant to notice, I now call up H.Res. 203 for purposes of markup and move that the committee report the bill unfavorably to the House. The clerk will report the bill.
H.Res. 203, of inquiry requesting the President and directing the Attorney General to transmit respectively certain documents to the House of Representatives relating to certain communications by the President of the United States.
Without objection, the bill is considered as read and open for amendment at any time. I'll begin by recognizing myself for an opening statement. The second resolution of inquiry that we must consider today is House Resolution 203, which was introduced on March 16th by Representative Quigley. This resolution requests information related to statements communicated via Twitter by the President with regard to the alleged surveillance of individuals at Trump Tower. As with the resolution of inquiry that we just considered, this resolution in no way compels the protection of information. It is akin to sending the administration a letter requesting the information. Moreover, as with the previous resolution, this resolution comes on top of an already existing investigation into the matter by both the House and Senate Intelligence Committees. It is unclear whether the FBI and the Justice Department are also investigating the matter covered by the resolution. But what is clear is that this resolution is unnecessary and premature, given that the committees of jurisdiction in both the House and Senate are already investigating and have the full authority to compel the production of any needed documents. Furthermore, given that the information sought in this resolution is almost certainly classified, the overly broad request contained in the resolution would appear to be inappropriate. As I noted regarding the resolution of inquiry that we just debated, we do not need to insert a non-binding resolution of inquiry into the middle of at least two ongoing investigations into this matter. Moreover, with respect to the agency that this committee has primary jurisdiction over, the Department of Justice, we know that it does not have the information sought by this resolution. We know this because Director Comey testified before the House Intelligence Committee last week that, and I quote, with respect to the President's tweets about alleged wiretapping directed at him by the prior administration, I have no information that supports those tweets, and we have looked carefully inside the FBI. The Department of Justice has asked me to share with you that the answer is the same for the Department of Justice and all its components. The Department has no information that supports those tweets. End quote. Given Director Comey's statement to the House Intelligence Committee last week, it is clear that the documents requested by this resolution are not in the possession of the Justice Department. This committee is exercising oversight into all aspects related to the potential Russian interference in the election and leaks of classified information by individuals with access to classified information. We intend to conduct this oversight objectively using the oversight tools already at the committee's disposal, but without resort to hollow, unenforceable resolution of inquiry like the one before us. I urge my colleagues to join me in voting to report this resolution unfavorably and will yield to the ranking member once we have reconvened. But at this point, because there are votes on the floor, the committee will stand in recess until the completion of this series of votes. The committee will reconvene. When the committee recessed prior to the last series of votes, we were considering HRes 203. And I had given my opening statement, and I now recognize the ranking member of the committee, Mr. Conyers, for his opening statement.
Thank you, Mr. Chairman. Members of the committee, I urge you all to consider and support House Resolution 203 brought by our colleague from Illinois, Mr. Quigley, a former member of this committee who's been with us for a long period in the audience today. President Trump has a long, colorful history of saying things that are simply untrue. The crowd at his inauguration was not the largest in history. He did not win the Electoral College by historic margins. He also did not win the popular vote, nor has he ever offered a shred of evidence that 3 million people voted illegally for Secretary Clinton in the last election. In the pre-dawn hours of March 4th, 2017, President Trump took to Twitter and proclaimed, quote, "President Obama was tapping my phones in October," end quote. He directed the statement at President Obama personally. Quotation, "How low has President Obama gone to tap my phones during the very sacred election process? This is Nixon Watergate. Bad guy." To be clear, this accusation is plainly false. There's no evidence whatsoever to support the notion that President Obama directed unlawful surveillance at candidate Trump. The allegation has been refuted by Speaker Ryan, Senator Richard Burr of the Senate Intelligence Committee, and FBI Director James Comey himself. I'm not interested in litigating the quotation marks that appeared in the president's tweets. His claim cannot be vindicated by reports of incidental collection of communications to and from Trump Tower as members of the transition team spoke to foreign officials who are rightly the subject of government surveillance. I'm also uninterested in pivoting to a discussion about surveillance reform. Members of this committee, liberal and conservative, understand the power of these surveillance programs and what the government can do to us with information that it collects. Mr. Chairman, I look forward to working with you on reform of Section 702. But we're here today to talk about an entirely different matter of national security. The president's wiretapping claim is more than an attack on his predecessor and more than an attempt to distract from the Russia investigation. The tweets and the reckless attempt to defend them represent a direct threat to national security. As the, I won't say conservative, Wall Street Journal editorial board put it, as the Wall Street Journal editorial board put it, quote, "If President Trump announces that North Korea launched a missile that landed within 100 miles of Hawaii, would most Americans believe him? Would the rest of the world? We're not sure," which speaks to the damage that Mr. Trump is doing to his presidency with his seemingly endless stream of exaggerations, evidence-free accusations, implausible denials, and other falsehoods. Quote continued, The latest example is Mr. Trump's refusal to back off his Saturday morning tweet of 3 weeks ago that he had, quote, found out that Barack Obama had my wires tapped in Trump Tower just before the victory on Election Day. He's offered no evidence for his claim, and a parade of intelligence officials, senior Republicans and Democrats, have since said they have seen no such evidence. Yet the president clings to his assertion like a drunk to an empty gin bottle. This is all in the quote. Rolling out his press spokesman to make more dubious claims, in quotation. I ask unanimous consent that the full column be placed in the record, sir.
Without objection, it will be made part of the record.
Thank you. Mr. Chairman, House Resolution 203 is designed for one purpose: to place the burden on President Trump to produce evidence for his claim or issue an apology. Simple as that. Even if the president fails on those fronts, and we have every reason to believe that he will, we will have shown our partners in the world that Congress will not condone this reckless behavior. To put an end to this dangerous falsehood, I urge all of my colleagues to support the Quigley resolution of inquiry. I thank you, sir, and I return any unused time. Just finished. Thank you.
Thank you. And I now recognize myself for purposes of offering an amendment, and the clerk will report the amendment.
Amendment in the nature of a substitute to H.Res. 203, offered by Mr. Goodlatte. Strike all that follows
Without
after
objection, the amendment will be considered as read, and I recognize myself to explain the amendment. As with the previous resolution of inquiry, I am offering this substitute amendment to make a minor clarifying change to the introduced text and to preserve the majority's procedural options on this resolution. The substitute adds in a missing exclamation point from one of the quotations in the base resolution and makes a stylistic change with regard to the numbering of the clauses in the resolution. In addition, as I mentioned in my statement on my previous substitute amendment, offering this substitute does allow the previous question to be called if necessary. I yield, and the ranking member has already been recognized. Well, I yield to the ranking member for any comments he has on the substitute.
I support the technical changes that you have put forward, sir.
I thank the gentleman, and the chair recognizes the gentleman from New York.
Thank you. I want to commend the chair for the stylistic changes. I think they're very apt. I hardly think, given the look of this room at the moment, that a fear about the necessity of a previous question is realistic, but I will not oppose the substitute on that grounds. I do want to talk, now is the time to talk on the substitute about the underlying motion, isn't it?
The gentleman is recognized for 5 minutes.
Thank you. I don't think I'll take all my 5 minutes, but I'll say this. The president's slander of former President Obama by tweeting out that he tapped me and it's illegal for him to be tapping him, a new low, and this is Nixon Watergate. Obama is a bad or sick guy, as he wrote, is just wrong. It's beneath a president of the United States, although apparently not beneath this one. But it's simply wrong. And it is designed to take attention away from the real questions that we discussed when we discussed the previous resolution of inquiry, I suppose an hour ago. The real questions are, I mean, they're manifold questions, but the real questions are all the questions about Russian influence in the election, which was clear. The Russians tried to subvert the election. They did what they did. And the real question is the collusion of the Trump campaign in that subversion of a free election. And that's what we ought to be investigating. And there are investigations going on. The FBI is investigating, has a criminal investigation. The Senate apparently has an investigation. The House Intelligence Committee, I won't call an investigation anymore, since the chairman is obviously in the tank for the president and is completely eliminated the possibility of a...
Gentlemen, suspend. I don't believe the gentleman's remarks are in accord with the rules of the House.
I'm just quoting this morning's New York Times.
Regarding the chairman of the Intelligence Committee.
Okay, I'll withdraw that, and I'll say the chairman of the Intelligence Committee is obviously trying to protect the president rather than have an honest investigation.
Can't say that either. You cannot impugn the motives of another member of the House.
Okay, I'll withdraw that, and I'll say that the actions of the chairman have obviously made an honest investigation impossible for whatever reasons he may choose to have done that, and that no one at this point on either side of the aisle in either house has any confidence that there will be a proper investigation by the House Intelligence Committee. There may very well be a proper investigation by the Senate Intelligence Committee. I would hope that we would do our share in investigations through these resolution of inquiry, but we're not. But the president, the subject of this resolution of inquiry, the president's allegation in various tweets that former President Obama tapped him, that former President Obama is a bad or sick guy, are slanderous, and they are not on it, and they are designed, if they have any purpose at all, they're designed to detract from a proper investigation of the real charges. So we ought to look into that, and I commend Mr. Quigley for this resolution of inquiry, and I urge its adoption. I yield back.
Are there any amendments to the amendment in the nature of substitute? For purpose, the gentleman from Georgia seek recognition.
I move to strike the last word.
Gentleman's recognized for 5 minutes.
Mr. Chairman, I find it ironic that President Donald Trump can communicate via Twitter, via his official Twitter account. He can tweet that he just found out that Obama had my wires tapped in Trump Tower just before the victory. Nothing found. This is McCarthyism. And then so he accuses the ex-president, he impugns his motives by saying that this is McCarthyism. And then he goes on March 4th, later at 3:49 a.m., this is early morning, 3:49 a.m., he tweets, "Is it legal for a sitting president to be wiretapping a race for president prior to an election turned down by court earlier, a new low?" And then he goes on to say that how low has President Obama gone to tap my phones during the very sacred election process. This is Nixon Watergate bad or sick guy. If, you know, when we're talking about impugning someone's motives and character, that is character assassination in plain view with a pistol to the head, a gunshot right there in Central Square for everyone to see. And then we on this committee are barred from discussing the motives of our colleagues in even in an indirect way. It's ironic to me. But the bottom line is that those tweets that the president made contain some accusations that, if true, would be stunning breaches of the law. If untrue, would be stunning breaches of protocol, would be false accusations against an ex-president, would be consistent with a pattern of behavior that was not in accords with the truth. And so this privileged resolution filed by Mr. Quigley, I rise in support of, and it simply asks for written communications regarding those tweets and evidence that supports them, if any exists. This is something that it would seem that this committee would rush to adopt. After all, it's not an investigation, but it very well could lead to an investigation if we were to get the information. And so just a simple quest for the information is all that is asked. When we see other committees or another committee, the only committee in the House charged with investigating any of these allegations against President Trump and his administration and his campaign, when we see that investigation being shut down, literally, as it has been for a week, due to some actions that were taken by its chair, and that's the only investigation going, it would seem that this committee would at least send out a request for some information to determine whether or not there was probable cause to proceed with an investigation, because certainly we have a reasonable and articulable suspicion that there may be some wrongdoing that has occurred, because the allegations that the president made against the ex-president are very serious indeed. Those are matters within the purview of this committee. This committee certainly should look into it if there is more cause to do so. And this resolution just simply asks for the executive branch to supply us with the information. It's a very reasonable request. Now, if there's opposition to the request, then at least we should hear that opposition. We're in debate right now on this resolution. I would challenge someone on the other side of the aisle to come forward with logical arguments to refute the need of our committee for this. And then, having heard that, I might vote in favor of the Republican position. But with no one, especially those who've been so vociferous in previous investigations by this committee of the previous president, not having anything to say about this is just very alarming. It raises the question of what are the motives of the other side? What are they thinking? That's what the American people want to know, and that's what I'd like to know, and I look forward to someone on the other side requesting time in opposition to this motion, because if no one speaks in opposition to it, then I would expect that common sense would dictate that my colleagues on the other side of the aisle would be in favor of it. It's just a request for information. It's no harm. If the administration doesn't respond to it, they're not legally obligated to have to respond to this resolution. If they don't, that's some evidence that we can look further, or that may add to our desire to get further information. If they respond, then well and good. If they clear themselves, wonderful. If not, then we have grounds to proceed.
The time of the gentleman has expired.
So with that, I will yield back.
Are there any amendments to the amendment? For purpose, the gentleman from Maryland seek recognition.
I want to move to strike the last word, and I do have an amendment, Mr. Chairman.
The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to HRS 203 offered by Mr. Raskin. Page 2, line 7.
Without objection, the amendment is considered as read, and the gentleman is recognized for 5 minutes on his amendment.
Mr. Chairman, thank you very much. The amendment would simply add to the scope of the investigation any meeting that took place between Representative Nunes, the chairman of the House Permanent Select Committee on Intelligence, and members of the White House on White House grounds on March 21st, 2017, and also relating to Chairman Nunes's announcement on March 22nd, 2017, that the intelligence community incidentally collected information about U.S. citizens involved in the Trump transition. And as we dig into this, Mr. Chairman, I'm reminded of the famous passage, "Oh, what a tangled web we weave when first we practice to deceive," because it seems like there are evasions upon miscommunications upon deceptions throughout this whole tangled web. When Chairman Nunes went to the White House with information that he did not go first to his committee with, it raised a number of very serious questions. Why did Chairman Nunes need to brief the president on documents clearly already in the possession of the White House? Why did he need to work with the White House to obtain and examine these documents when he has subpoena power as chairman of the Intelligence Committee? Why would he brief the president, whose associates may very well be the subject of the Intelligence Committee's investigations and the FBI investigations? And did he, in fact, inadvertently become the leak that our colleagues on the other side of the aisle have frequently invoked about revealing classified information related to ongoing investigation and surveillance of foreign nationals? So there's a number of very serious issues that emerge because of Chairman Nunes's breach of standard legislative protocol in going first to the White House with this information. Mr. Chairman, if we take a step back, I think we have to recognize that this is a very serious time in the history of the world. All over the earth, there are authoritarians and despots and dictators and kleptocrats on the march. And Vladimir Putin is at the center of this attack on the rule of law and human rights and democratic values. In Russia, on Sunday, tens of thousands of citizens took to the streets to protest corruption and violation of human rights. Many of them were arrested. Some of them are still in jail right now. They had the courage to face down Vladimir Putin's thugs throughout Russia on Sunday. Those are the people we should be standing with. Those are the people we should be having meetings with, overtly or covertly. But we heard nothing from the president. We heard nothing from the vice president in favor of the massive demonstrations that took place in Russia against the corruption of the Putin regime. What do we know? Well, we know from 17 of our own intelligence agencies that Vladimir Putin had a comprehensive plan to undermine and destabilize American elections through espionage on this land, through cyber sabotage, through the production of fake news, and through propaganda disseminated on the internet in order to fix the election according to Putin's favored candidate. Now, we should be standing with the people who are protesting and not with the billionaires and the autocrats and the kleptocrats who are running Russia. That's why this is such a big deal. And all we are asking for is an honest accounting of what took place, what happened. We know that Vladimir Putin and his team essentially engaged in a massive worldwide independent expenditure in the 2016 presidential campaign. If you put it in FEC terms, it was a massive, illegal, independent expenditure against us.
Will the gentleman from Maryland yield?
Yes, by all means.
Have you been able to find anybody that switched their vote from Hillary Clinton to Donald Trump because it would please Vladimir Putin? I haven't.
Well, reclaiming my time, it's completely irrelevant to me whether it influenced 10 million votes, 10,000 votes, or 10 votes. It was an attempt to undermine and subvert our election. And I would hope that it...
Well, the gentleman yield further.
Yes, by all means.
Well, you know, if you can't find anybody that did switch their vote because it would please Vladimir Putin, then what he did failed.
Well, let me ask you a question, if you would yield back for a second. Do you think anyone was influenced by the Republican Party's platform in the 2016 election?
Some people may have been, some people may not have been.
Wait, do you agree that Vladimir Putin, through his emissaries and the Donald Trump campaign, altered the Republican National Committee platform in 2016?
No.
Well, then we have to have a separate hearing on that because there's extensive documentation about how the Trump campaign changed the Republican platform and changed the policies of the Republican Party to conform to the Russian line. But reclaiming my time, Mr. Chairman, the Russians engaged in an independent expenditure. The only question is, was it a coordinated independent expenditure? And those people were saying that the Trump campaign knew nothing about it, should have nothing to fear from an open, honest, comprehensive investigation, which is what 2/3 of the American people are asking for. At the very least, we should go ahead and pass this resolution of inquiry as amended.
The
I yield back.
time of the gentleman has expired. The chair recognizes himself in opposition to the amendment offered by the gentleman from Maryland. This amendment does nothing to add to an otherwise unnecessary resolution. The House and Senate Intelligence Committees are investigating this matter, and there is no reason to request this information at this time. As Mr. Raskin noted in his remarks, the Intelligence Committee has the subpoena power and can request whatever information they need, House or Senate. They do not need this resolution to help their investigation. Finally, the information sought by this amendment is surely classified information, and this overly broad resolution of inquiry is no way to go about requesting classified information. I urge my colleagues to oppose the amendment. Minutes.
I want to thank my distinguished colleague from Maryland for offering this amendment, and I want to also thank my colleague from New York, Representative Nadler, for leading the way as it relates to these resolution of inquiries, which I think are incredibly important, and simply an effort to get at the truth. Now, I have great respect for my colleagues on the other side of the aisle, but I'm struggling to process some of the logic that has been articulated here today in opposition to these resolutions of inquiry. In particular, this notion that if we have yet to determine that Vladimir Putin successfully was able to change the hearts and minds of individuals as a result of the massive and unprecedented document dump that undermined, in the view of many Americans, Hillary Clinton's credibility. It's not rocket science what was happening. But if we can't conclusively, scientifically, mathematically determine at this point that no votes were changed, that what Vladimir Putin, a thug and a dictator, did should be swept under the rug, I'm struggling to understand that logic. I can't tell you to any degree of mathematical certainty whether Nixon's break-in at Watergate altered the results of the 1972 election, which resulted in him winning a second term as a result of a landslide. I don't know if it altered the results. I don't know what information he actually gathered from that break-in. We do know that he committed a crime, that he was a crook, and he's gone down in disgrace. Now, Vladimir Putin's Russia does not have the best interests of the United States at heart. I don't know why that's so difficult for some in this town or throughout this country to process. And it was an intentional, deliberate, malicious attack on our democracy to create the type of partisan divide that we actually are seeing unfold here in the Congress and throughout the country, to undermine the integrity of our democracy and our unity and our values. And all we're simply saying is, let's try to get at some of the truth of what occurred. Now, I've heard my distinguished colleagues say, well, there is a House Intelligence Committee investigation. Are you kidding me? That's not a 3-ring circus, it's a 4-ring circus right now. P.T. Barnum would be proud. There's no credibility to that investigation. There is no effort to proceed in a bipartisan, dispassionate fashion. One of the reasons why I'm proud to serve on the Judiciary Committee is because it's had a great tradition, by and large, of functioning in that fashion, particularly in areas where we've got jurisdiction, such as over the Department of Justice. It's also been interesting to me that there's been a very aggressive tendency throughout the 115th Congress of trying to take down words whenever we make any reference to the President of the United States of America. But the 45th President can call a twice-elected President of the United States a bad or sick guy and lie about whether he ordered a wiretap or not, and there's a big problem with what some have said about this president, but there's no issue in terms of finding out the truthfulness as it relates to this Twitter episode that Donald Trump engaged in. I just can't figure it all out. And I continue to hold out hope that at some point we can figure out some common ground for investigating this attack on our democracy that should be offensive to everyone, Democrats and Republicans alike, because it will happen again. And next time, it may impact people on the other side of the aisle. And so this is not a Democratic issue or a Republican issue. It's an American issue, and hopefully we can figure out a way at some point in time to be able to get the information in a bipartisan fashion that we can present to the great people of this country, and I yield back.
Chairman.
Mr. Chairman.
For purpose, the gentleman from New York seek recognition.
Speak on the amendment.
Gentleman's recognized for 5 minutes.
Thank you. I won't take 5 minutes. I'll simply point out two things. One, the chairman in his remarks in opposing this amendment said, among other things, that this amendment explicitly calls for information which is probably classified. And let me point out that the underlying resolution, which reads in relevant part, the President resolved the President's request the Attorney General of the United States is directed to transmit respectively in a manner appropriate to classified information if the President or the Attorney General determines appropriate to the House of Representatives, et cetera, explicitly provides for classified information to be handled appropriately as this committee is entitled to classified information. So it is not a derogation of the amendment to say that it requires the turning over to the committee of information that might be classified. That is true, but that's appropriate. This committee is entitled to receive classified information if the proper procedures are followed.
Would the
Yes.
gentleman yield?
Sure.
I thank the gentleman for yielding. 2 points. First of all, at the request of both the majority and the minority, the chairman and the ranking member were given a classified briefing by the director of the Federal Bureau of Investigation that confirmed that there is an investigation taking place. Now, we should not be supplanting that with a blunderbuss approach where we submit a resolution of inquiry which doesn't even carry the weight of a subpoena asking for information that is already being investigated by other committees and by the executive branch.
Claiming my time, the amendment that the chairman opposed on the grounds, among others, of the classification I talked about, has nothing to do, as far as I know, with what the chairman and the ranking member were briefed on. It has to do with any meeting that Representative Nunes, the chairman of the House Intelligence Committee, attended on White House grounds on a certain date, and with his announcement that the intelligence community incidentally collected information about U.S. citizens involved in the Trump transition, unquote. All of this occurred in the last few days. It occurred on the 21st and 22nd.
The gentleman would yield
not
further.
for the moment. It occurred on March 21st and 22nd, and is in effect a new topic. I'd simply make one other observation, and that is that...
Would the gentleman yield on that point? Because the chair did not rule it non-germane, because it is germane to the underlying investigation.
No,
It's already taking place. And for this committee to, through a resolution of inquiry, to seek information from another committee of the very House, this is not the appropriate committee to do that. So,
well, reclaiming my time, we're not requesting we're not requesting information from another committee of the House. We're requesting it from the Attorney General, number one. And number two, it has nothing to do with germane. It's this stuff is clearly germane. What I was saying was that it was probably not covered by the briefings that were received, which I presume was prior to March 21st, 22nd. But second, I want to make one other point, and that is that whether one can prove that the Russian intervention in our election affected votes or affected sufficient votes to have turned the election is by definition unknowable. You cannot ever prove, given the fact that we have a secret ballot, you cannot ever prove that any action, proper or improper, affected a certain number of votes or affected any votes. One can make assumptions. The political scientists will say this was very important and that wasn't, but one cannot prove it. The standard is to protect the integrity of our elections. Did someone break the campaign finance law, for instance? Did he overspend by $2 million? Not did $2 million change 500,000 votes, but did he break the law in so doing? I'm not talking about any particular person at the moment. Did an improper action violating our laws and our practices occur? Clearly, the Russians broke our laws in many ways and attempted to subvert our election. Whether they succeeded in changing the outcome is unknowable and not the relevant question. The relevant question here is, a foreign power having sought to subvert an American election, did Americans, specifically the Trump campaign people, did they collude with them? If they did, they committed crimes. If they did not, they didn't commit crimes. But if they did, they committed not only technically crimes, but they helped subvert an American election, maybe changing the outcome, maybe not changing the outcome. That's not the question. That is unknowable. But did they try to subvert a fair election? And did they do things to try to conspire with a foreign power to subvert an American election? That is a key question for the United States. It's key to the integrity of our elections, and it's key to making sure that nothing like that, if it happened, if there was such collusion, happens again. I yield back.
Mr. Chairman. Mr. Chairman.
The chair recognized himself for purposes of putting in the record an article entitled "Clinton Ally Says Smoke But No Fire, No Russia-Trump Collusion." Former CIA Director Michael Morrell, who endorsed Hillary Clinton, cast out Wednesday night on allegations that members of the Trump campaign colluded with Russia. Morrell, who was in line to become CIA Director if Clinton won, said he had seen no evidence that Trump associates cooperated with Russians. Without objection, be made a part of the record. For purposes of the gentleman from Georgia, the gentleman from Louisiana. We're going to this side of the aisle. The gentleman from Louisiana is recognized for 5 minutes.
Thank you, Mr. Chairman. We have been subjected for quite some time this morning to arguments from our colleagues on the other side. These resolutions of inquiry, as you've rightfully pointed out, are not only procedurally incorrect, it's a violation of House rules for members of this committee to continually impugn the motives of another committee of this House and its chairman, the House Intelligence Committee. I also just want to point out that we keep hearing about how the president tweeted something at 3 a.m. about his predecessor, but I was just sitting here Googling, because I can hardly listen to these arguments much longer, and Time Magazine, let me just read you the opening of an article, October 14, 2016. President Obama tied Republican presidential nominee Donald Trump to the Republican Party, arguing that they have long fed voters a, quote, swamp of crazy at a campaign event in Columbus, Ohio. I just want to point out, Mr. Chairman, that's one of many examples that could be cited. It's implied this morning that the previous president was some sort of paragon of virtue and civility and that Donald Trump is not. There's enough of this to go around. And we can sit here all day talking about, you know—
Gentlemen, yield.
Just a moment. We can talk about names that have been said back and forth by nominees and by sitting occupants of the White House, but that's not relevant to what's happening here today. And
The gentleman yield.
In just a moment. And I just think that we've heard all the arguments, and I hope that we can get to a vote on this soon enough so we can move on with the important business of the House. Thank you.
The gentleman yield.
I'll yield.
Thank you. I would point out, and maybe I'll ask the gentleman if he will concede, there is a difference between campaign rhetoric, by which I take back campaign rhetoric, between making an observation about your opinion of someone else, which is what the president was doing in that quote, in the context of a campaign, but even so, it's his opinion of somebody, and a crime, accusing somebody, I should say, of a crime. When President Trump accused President Obama of wiretapping him, he was accusing him of a crime. There's a difference between an opinion of a political, someone on the other side of the political aisle, or for that matter, someone on your side of the political aisle, and accusing someone of a crime. I yield back.
I would just respond to say that however we classify the rhetoric on both sides, it doesn't change the question of jurisdiction, the motives of the chairman of the Intel Committee, and all the things that are being subjected to question this morning. That's the real issue before us, and I think that we've got to allow the other committee to do their job, and I don't think they've completed that yet. And so I think this is an unwarranted and unnecessary intrusion into the important work of another House committee, and we ought to let them finish their task and complete their job. And I'll yield.
Chair, thanks, gentlemen. For purpose of gentleman from Texas, seek recognition.
I thank the chairman for his courtesies. I rise to
Gentleman is
strike-
recognized for 5 minutes.
strike the last word. Let me acknowledge the difference of opinion in all of my colleagues. And again, because of the sacredness and the crucialness of what the American people perceive the Judiciary Committee to be, if any committee, to uphold the Constitution, I respect the gentleman from Louisiana and others who've expressed a view different from mine. I rise to support the gentleman from Maryland's underlying amendment and the underlying bill. And the only point that I'd make about the gentleman's amendment is that as the holder of the Constitution, and though there are House rules, there are rules of the Republican Conference, there are Democratic caucus rules, it is important that we at least have a unified view, nonpartisan, bipartisan, that when rules are broken, rules are broken. And so, with respect to Mr. Nunes, Chairman Nunes, it certainly behooves us to find out what rules were broken. When someone leaves the Hill, goes to the White House, and then portrays themselves the next day as having found information that the president needs to know with a rush down to the White House. Please be reminded of the equal branches of government. So I want to support the underlying resolution regarding the issue of untruth. I will not even use the word lying in the context of the highest office of the world, of this nation and the leader of the free world, out of respect. Untruth. And so it has been noted that Mr. Trump has made 317 false or misleading claims, untrue. And it is important to note, as I alluded to before, that this particular committee has a myriad of responsibilities. In the Constitution, it talks about the removal of the president. And it indicates that one of the factors, besides conviction of treason, bribery, or other high crimes and misdemeanors. And so, quietly, I want to say that this committee has withstood major investigations. I said this earlier, from Waco to impeachments. One impeachment in particular did not proceed to a conviction. The basis, I believe, was that it did not appear to associate itself or relate to governance. What we're talking about here in the underlying resolution of inquiry to get facts is about governance. It is about a sitting president who accused a former sitting president of untruths, of saying that I have been wiretapped by this former president, and on the basis of those 4 tweets in writing. There's something that lawyers know that is so concrete about writing. It doesn't go away. Even in technology, writing stays in place. Tweets stay in place. And the highest law enforcement officer, in the context of police, the director of the FBI, testified under oath absolutely that they found no evidence relating to Mr. Obama wiretapping before or after Mr. Trump. He did not say Mr. Obama's extended relatives or Mr. Obama's staff. He said Mr. Obama. And so in essence, we have an unfortunate circumstance that Hamilton has written about. And Hamilton has written, the Hamilton of yesteryear, public trust can be abused. And that is the issue that is the underlying resolution. It is the special responsibility of the government, as written in Trump wiretap tweets, raise risk of impeachment, Mr. Noah Feldman, I ask unanimous consent to put into the record. The government's special responsibility has 2 bases. One is that you can't sue the government. If a citizen said something about Mr. Obama, he could sue for libel. But the president cannot be sued. And so he has made these statements. And so the question is, what is his responsibility as someone who governs? The second reason the government has to be careful about making unprovable allegations is that it's the bully pulpit is greater than any other. And so the idea that he can make 317, 420 untruthful statements and go without any recognizing reprimand, then I would make the argument that this committee must do its job. This resolution of inquiry, Mr. Chairman, must go forward. We must have the information. We must follow the trail, the facts.
time of the gentlewoman
and we
has
may
expired.
have a situation of Article 2, Section 4 in proceeding
The time
on
of the
Mr. Trump
gentlewoman has
on
expired.
impeachment. I yield
The
back.
gentleman from Georgia seek recognition.
I move to strike the last.
Gentleman's recognized for 5 minutes.
I rise in support of the Raskin Amendment, which simply adds to the list of documents that is requested under the resolution, any documentation having to do with Representative Devin Nunes, Chairman of the House Permanent Select Committee on Intelligence, insofar as his visit to the White House grounds on March 21st, 2017 is concerned, and also his announcement on March 22nd, 2017 that the intelligence community incidentally collected information about U.S. citizens involved in the Trump transition. That's the only thing that the Raskin amendment adds to the resolution, which in and of itself is just and is, there lies just cause for its passage. We have some very serious allegations that have been made, very important statements that have been made, very important actions that have been taken as a result of the statements. And Mr. Chairman, what I find is that there's a reason for people telling the truth. It's usually because the truth benefits them in some way. But then on the other side of the truth, there's lies. And the reason why people lie is because they want to hide the truth, because the truth will hurt them. And so when you have an issue that has been joined, we have facts, we have allegations that have been made, we can't rectify what's been said because there are opposing positions, and they fall, and the issue falls within the bailiwick of this committee. It would seem to me that this committee would take just a small action in requesting documentation from the executive branch, because after all, this is the committee with jurisdiction over impeachment. And that is the specter that continues to arise from the ground, is the issue of impeachment. And so it's not that we are hell-bent on impeachment, it's just simply in good faith asking for information that could rise to a certain level, or it could be such that we don't want to go down that road. But when people tell the truth, that's one thing. When people lie, that's another thing. When you remain silent, when you've got a contradiction on a matter that is either the truth or is a lie, and the matter is important, and you remain silent about it, then it means you must not care about the issue, or you're trying to be a part of the cover-up, or you're trying to be a part of hiding the situation. And I don't want this committee to have the distinction of being a part of a cover-up, nor do I want it to be accused of not caring about whether or not the truth has been told or whether or not a lie has been told, and the matter is within the jurisdiction of this particular committee. I don't want that to happen to this committee, because this committee has a reputation of being greater and better than that. And so I ask my colleagues to support the Raskin Amendment, and I ask my colleagues to support the overall or the base resolution, and with that, I yield back.
First, the gentleman from Rhode Island seek recognition.
I move to strike the last word.
Gentleman's recognized for 5 minutes.
I rise in support of the Raskin Amendment and the underlying resolution. And I would say to my colleagues, a resolution of inquiry is, in fact, the proper vehicle for members of this committee to gather information, to learn facts. It's very surprising to me that my colleagues on the other side of the aisle are so resistant to learning and to gathering information so that we can find out where this leads. This is about protecting our democracy, protecting the very way of life in this country. You know, we ask the men and women who serve in the military in very dangerous places around the world to give their lives to sacrifice in service of our country, to defend this democracy. It seems to me the very least we can do is show the same kind of courage in a well-ventilated, comfortable hearing room to learn the facts and do what's necessary to defend our democracy and to do our part. There's been a suggestion that, well, we don't have any way to prove that anyone's mind was changed. Of course, as Mr. Nadeau said, we don't know that. But we do know there are 8 million people who watch RT weekly. That's their audience. We know as part, the 17 intelligence agencies in our country concluded that the Russians, led by Vladimir Putin, engaged in a very sophisticated campaign that included the use of RT, Russian propaganda, of paid trolls, of fake news, of breaking into the DNC to bolster the campaign of Donald Trump and to undermine the campaign of Hillary Clinton. Those are the facts. We know there have been 5 individuals in the close Trump orbit who have now been excluded because of their Russian ties and then their failure to tell the truth about the relationship with the Russians or their meetings with the Russians or their conversations with the Russians. And some people have suggested, well, if you can't prove that it changed the outcome, we shouldn't care. And one of my colleagues described it this way. If someone takes a gun and shoots at your head and misses, aren't you still interested to find out who shot at you and why and making sure it never happens again? So the fact that whether they were successful or not, the Russians will continue this. They're doing it in Germany. They're doing it in France. This is part of a sophisticated campaign to undermine Western democracies. And if we think they're not watching to see how we respond to this, we're making a big mistake. So this resolution should be adopted by both sides of the aisle so that we can get information to begin to discharge our responsibilities in this committee. And as the gentlelady from Texas reminded us, this is a committee that has very special responsibilities with respect to our Constitution and with respect to impeachment. We have a responsibility to begin to collect information to discharge those responsibilities. And I would say to my colleagues on the other side of the aisle, if this is of no interest to you, you don't have to look at it. Let us collect the information. Let us study it. Let us find the facts, because the American people are entitled to know those things. If it's of no interest to you, no one will obligate you to read it. But all we're asking is allow us to get the facts so that we can understand where this leads. This is an unprecedented intrusion into an American presidential election. It should be of concern to all of us. And so I would implore my colleagues to support.
Would the gentleman yield?
I'm happy to yield to Mr. Raskin first and then to the chairman.
Thank you very much. I want to commend the distinguished gentleman from Rhode Island for his remarks. And one of the things that he did for us, I think, is to make very clear what's at stake here. What we have essentially is a massive outside independent expenditure in an American election by foreign power, by the Russians. Now, everybody, I think, agrees to that at this point. Before the intelligence agencies released their public report, all we heard was denial, that it's made up, it's hallucinatory, it's political, and so on. Then the FBI and the CIA and the NSA and all the intelligence agencies said, this is true. Putin undertook to subvert and undermine our election with espionage, with cyber sabotage, with fake news, with propaganda. So then the question is, okay, what are we going to do about that? But then the question is, was there collusion on the part of people within the Trump campaign? And again, we were told that's ridiculous, that's absurd, that's outlandish. And then General Flynn, the national security advisor, was forced to resign because of his contacts with the Russians. And then Attorney General Sessions, it turns out, didn't tell the truth at his hearing. He did not tell the truth about his contacts with the Russians, and he was forced to recuse. And every day, we are getting more and more revelations about contacts between the Trump campaign and people who practice this massive negative intervention in our campaign, this massive independent expenditure. The question for us is, was there collusion? Why should any of us be afraid to get to the bottom of that? That's our responsibility as the Judiciary Committee. I yield back.
The question occurs, for the purpose of the gentleman from California seek recognition.
I move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chair. I support both the underlying resolution as well as this amendment. And on the underlying resolution, the reason this is so important is because the President of the United States made a very serious allegation that Trump Tower was wiretapped. If that were true, this is what it would mean. And keep in mind, the President has access to the highest levels of classified intelligence. I'm going to take him at his word. And if he says he was wiretapped, it would mean that U.S. intelligence officials or U.S. agents investigating criminal behavior believe there was either agents of a foreign power at Trump Tower or criminal activity. And then they convinced a federal judge of that, either an independent FISA court judge appointed by Chief Justice Roberts or a federal district court judge, all with life tenures, who concluded, yes, there was probable cause that there was criminal activity at Trump Tower or there were agents of a foreign power. That's why we need these documents. I want to find out what those wiretaps captured. Were there agents of foreign power? They were talking to members of the Trump campaign. We should get that information in those documents.
Would the gentleman yield? I thank the gentleman for yielding. This question has already been answered. We know this because Director Comey testified before the House Intelligence Committee just last week that, and I quote, with respect to the President's tweets about the alleged wiretapping directed at him by the prior administration, I have no information that supports those tweets, and we have looked carefully inside the FBI. The Department of Justice has asked me to share with you that the answer is the same for the Department of Justice and all its components. The department has no information that supports those tweets. So the jurisdiction of this committee, oversight of the Department of Justice, and we have submitted requests on both the majority and minority side for information. This is a meaningless resolution of inquiry because it does not answer or even have the prospect of answering any question that has not already been answered by the people that the resolution is directed toward.
The gentleman yields.
The Department of Justice.
So thank you, Mr. Chair, because that gets me to the second part of my statement, which is, or the President of the United States just made this up. So if he made this up, then no one should oppose this resolution inquiry because there's going to be no documents on it. Now, here's why I support the amendment, because the amendment talks about something different. The amendment talks about the chair of the Intelligence Committee. And this is why it's so important, because under this amendment, it says, we're trying to seek information on Representative Devin Nunes' announcement that the intelligence community incidentally collected information about U.S. citizens involved in the Trump transition. There's an article from the Daily Beast yesterday. The title of it is that Devin Nunes could be facing an ethics probe for spilling secrets. So under the way the House Ethics Committee works, if a member is suspected of disclosing classified information, they would face an ethics probe, and anyone can make that complaint. I believe that the chair of the Intelligence Committee is now compromised, which is why the Judiciary Committee now has to exert its oversight and take much more of a role, because we now can no longer have an impartial investigation by the House Intelligence Committee. And that's why I support this amendment. And it's also why I support the second part of this amendment, which asks for information when the chairman of the House Intelligence Committee went to White House grounds to review this information. So the White House has said that, well, initially, that it didn't pass a smell test, that White House officials gave this information to the chair of the Intelligence Committee. White House press security has now backed away from that statement. My view is, if the chair of the Intelligence Committee went to the White House to look at classified information, it is reasonable that White House officials gave documents at the White House during this meeting. And that's what this amendment would try to seek.
Would the gentleman yield?
So with that, I support both the amendment and underlying resolution, and now I will yield back.
Thank you. I just point out that since this amendment deals with Representative Nunes's announcements and other activities in the last few days, it post-dates the statement by Director Comey that they had no information that the president was telling the truth, and it's now relevant to get any information which Nunes has, which may bear on that. And I commend the sponsor of the amendment, and I commend the sponsor of the resolution on that. I yield back.
Time of the gentleman has expired. The question occurs on the amendment offered by the gentleman from Maryland. All those in favor respond by saying aye.
Aye.
Those opposed, no. Opinion of the chair, the noes have it. The amendment is not agreed to.
Could I request a roll call vote, Mr.
The
Chairman?
recorded vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
No.
Mr. Goodlatte votes no. Mr. Sensenbrenner? Mr. Sensenbrenner votes no. Mr. Smith? Mr. Shabbat? Mr. Shabbat votes no. Mr. Issa? Mr. King? Mr. Franks? Mr. Gomert? Mr. Jordan? Mr. Poe? Mr. Chaffetz? Mr. Chaffetz votes no. Mr. Marino? Mr. Gowdy? Mr. Labrador? Mr. Labrador votes no. Mr. Farenthold? Mr. Farenthold votes no. Mr. Collins? Mr. Collins votes no. Mr. DeSantis? Mr. DeSantis votes no. Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson votes no. Mr. Biggs? Mr. Biggs votes no. Mr. Conyers?
Aye.
Mr. Conyers votes aye. Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Johnson of Georgia? Mr. Johnson votes aye. Mr. Deutsch? Mr. Deutsch votes aye. Mr. Gutierrez? Ms. Bass? Mr. Richmond? Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Mr. Schneider? Mr. Schneider votes aye.
The gentleman from South Carolina.
Mr. Gowdy votes no.
The gentleman from California. Gentleman from
Mr. Issa votes no.
Iowa. Gentleman from Arizona.
Mr.
Gentleman from Texas, Mr. Gomert. Gentleman from Ohio.
What is this? Oh, how am I?
I went too fast.
Mr. Chairman, how am I recorded?
Let the clerk catch up here. I
All right.
think I moved too fast. The gentlewoman from Texas.
Aye.
Ms. Jackson Lee votes aye.
The gentlewoman from California, Ms. Bass.
Ms. Bass votes aye.
Has every member voted who wishes to vote? The clerk will report. You're recorded as an aye.
Mr. Chairman, 11 members voted aye, 18 members voted no.
And the amendment is not agreed to. Are there further amendments to H.R. First, the gentleman from Wisconsin. Okay. Are there further amendments to House Resolution 203? Reporting quorum being present, the question is on the motion to report the bill, House Resolution 203, as amended, unfavorably to the House. Those in favor respond by saying aye. Aye. Oh, I'm sorry, we have to do the substitute first. The question is on the amendment to the amendment in the nature of a substitute. Those in favor respond by saying aye.
The amendment nature, question is on the amendment in the nature.
Okay, the question is on the amendment in the nature of a substitute. All those in favor respond by saying aye. Those opposed, no. In the opinion of the chair, the ayes have it, and the amendment is agreed, and the amendment in the nature of substitute is agreed to. A reporting quorum being present, the question is on the motion to report the bill, House Resolution 203, as amended, unfavorably to the House. Those in favor respond by saying aye. Aye. Those opposed, no.
No.
In the chair, the ayes have it, and the bill as
Record
amended.
vote is
A
required.
recorded vote is requested, and the clerk will call the roll.
Mr. Goodlatte?
Aye.
Mr. Goodlatte votes aye. Mr. Sensenbrenner? Mr. Sensenbrenner votes aye. Mr. Smith? Mr. Shabbat? Mr. Shabbat votes aye. Mr. Isa? Mr. Isa votes aye. Mr. King? Mr. King votes aye. Mr. Franks? Mr. Franks votes aye. Mr. Gomert? Mr. Gomert votes aye.
Aye.
Mr. Jordan?
No, wait a minute.
Mr. Jordan votes yes. Mr. Poe?
Oh,
Mr. Chaffetz? Mr. Chaffetz votes aye. Mr. Marino? Mr. Gowdy? Mr. Labrador? Mr. Labrador votes yes. Mr. Farenthold? Mr. Farenthold votes aye. Mr. Collins? Mr. Collins votes aye. Mr. DeSantis? Mr. DeSantis votes aye. Mr. Buck? Mr. Buck votes aye. Mr.
The
Ratcliffe?
clerk will suspend. I want to remind members we have one other matter to take care of, acknowledging a longtime member of the committee. So if you can remain for another minute after the vote is recorded, we would appreciate that very much. And the clerk will resume the roll call.
Mr. Ratcliffe?
Alexander.
Ms. Roby? Ms. Roby votes aye. Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson votes aye. Mr. Biggs? Mr. Biggs votes aye. Mr. Conyers?
No.
Mr. Conyers votes no. Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Cohen votes no. Mr. Johnson of Georgia? Mr. Johnson votes no. Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Ms. Bass votes no. Mr. Richmond? Mr. Jeffries? Mr. Jeffries votes no. Mr. Cicilline? Mr. Cicilline votes no. Mr. Swalwell? No. Mr. Swalwell votes no. Mr. Liu? Mr. Liu votes no. Mr. Raskin? Mr. Raskin votes no. Ms. Jayapal? Ms. Jayapal votes no. Mr. Schneider? Mr. Schneider votes no.
The gentleman from Texas, Mr. Poe.
Mr. Poe votes yes.
The gentlewoman from California.
Ms. Lofgren votes no.
The gentlewoman from Texas.
Not recorded.
You are not recorded.
Ms. Jackson Lee votes no.
The gentleman from South Carolina.
Mr. Gowdy votes yes.
Has every member voted who wishes to vote? The clerk will report.
Excuse me, how am I recorded? Raskin?
No.
No, okay, thank you.
No. Mr. Chairman, 19 members voted aye, 14 members voted no.
Clerk will suspend. If the gentleman from Florida, Mr. Deutsch. Now the clerk will report.
Mr. Chairman, 19 members voted aye, 15 members voted no.
The ayes have it, and the bill as amended is ordered reported unfavorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. And I thank the members for staying. I would now like to take a moment to recognize a member of the committee staff, Douglas Alexander, who after 16 years of service to the Judiciary Committee will be retiring from federal service this Friday, March 31st. Doug joined the committee as our printing clerk in 2001 under Chairman Sensenbrenner. Since that time, he has been a loyal and devoted member of the Judiciary Committee staff, serving both the majority and minority, working under Chairman Smith, Chairman Conyers, and myself. Through the years, Doug has tirelessly exhibited a high degree of professionalism and a great attention to detail, both of which are essential qualities in this line of work. Doug has consistently generated quality work product on behalf of this committee and by extension for the American people. Over the years, we have all come to appreciate not only Doug's devotion to service, but also his quick wit, gentle demeanor, and willingness to always share a kind word with his coworkers, especially when the subject is DC sports. We greatly appreciate Doug's service and years of hard work to the Judiciary Committee, congratulate him and, of course, his wife, Shirley, on his retirement, and wish him the best of luck as he starts this new chapter in his life. Doug, please accept my sincere thanks for a job well done, and I know the ranking member has similar sentiments that he would like to share, and he's recognized.
Thank you, Mr. Chairman. Members of the committee, Doug Alexander is one of those workers who works for Democrats and Republicans and has done so for 16 years, as has been noted already, to ensure the smooth operation of committee business. His work has been conducted with utmost care and professionalism, and we will sincerely miss his presence here. He's watching now, and I want to join my chairman, and all of you want to join all of us in thanking you, Doug, for your years of work and best wishes in whatever your new endeavors may be. And thank you, Mr. Chairman. Yep.
Doug is not here in the room, but I know for a fact that he is watching, so these sentiments are being conveyed. I thank you all for your participation today. This concludes our business, and the markup is adjourned.